Aloha mai kako, good morning. This is the October 7th, 2020 Land Use Commission meeting and is being held using interactive conference technology, linking video conference participants and other interested individuals of the public via the Zoom internet conferencing program in order to comply with state and county official operational directives during the COVID-19 pandemic we are living through. Members of the public are also viewing the meeting via the Zoom webinar platform. For all meeting participants, I would like to stress the importance of speaking slowly, clearly, and directly into your microphone. Before speaking, please state your name and identify yourself for the record. Also, please be aware that all meeting participants are being recorded on the digital record of the Zoom meeting. Your continued participation is your implied consent to be part of the public record for this event. If you do not wish to be part of the public record, you should exit this meeting now. This Zoom conferencing technology allows the parties and each participating commissioner individual remote access to the meeting proceedings via our own personal digital devices. Please note that due to matters entirely outside of our control, occasional disruptions to connectivity may occur for one or more members of the meeting at any given time. If such disruptions occur, please let us know. You can use the chat box be patient as we try to restore the audiovisual signals so we can effectively conduct business during the pandemic. My name is Jonathan Lee K.K. Scheuer. I'm currently serving as the chair of the State Land Use Commission. Along with me, Commissioners Edmund Axon, Don Chang, Gary Okuda, Arnold Wong, our LUC Executive Officer, Daniel Ordenker, LUC Chief Planner, Scott Derrickson, Chief Clerk Riley Hakoda, our Deputy Attorney General Colin Lau, and our court reporter Jean McManus are all on the island of Oahu. Commissioner Cabral is on Hawaii Island. Commissioner Ohigashi is on Maui, and Commissioner Giovanni is on Kauai. We currently have 8 sitting members of a possible 9. Our first order of business is the adoption of the September 24th through 25th September 23rd and through 24th, 2020 minutes. Mr. Hakoda or Mr. Derrickson, has there been any written testimony submitted on the minutes approval?
Mr. Chair, this is Riley Hakoda. There have been no public comments on the minutes.
Okay. Are there any members of, sorry?
I thought you called for a motion.
No, I need to actually just check if there's anybody who's in the public who might wish to testify purely on the adoption of the minutes. If so, use the raise your hand function in the Zoom meeting and I will bring you in. I see nobody, so I will happily entertain a motion.
I so move to adopt the minutes.
There's a motion by Commissioner Ohigashi, a second by Commissioner Cabral, affirmed by Shaka, in addition to the waving of hands. Is there any discussion on the motion before us? If not, Mr. Ordenker, please poll the commission.
Thank you, Mr. Chair. Commissioner Cabral.
Yes.
Commissioner Okuda.
Yes.
Commissioner Wong.
Yes.
Commissioner Ohigashi.
Yes.
Commissioner Axon.
Aye.
Commissioner Giovanni.
Aye.
So Commissioner Chang.
Aye.
Chair Scheuer.
Aye.
Thank you, Mr. Chair. The motion passes unanimously.
Okay, thank you. Our next agenda item is the tentative meeting schedule. Mr. Ordenker, please continue.
Thank you, Mr. Chair. Tomorrow we will be once again meeting by Zoom on the Hawaii Memorial Park matter. On October 21st, we will be taking up the LNR matter.
HCPO.
That's HCPO. The 22nd is also HCPO. On November 4th, we will take up the HALEKUA development, motion to amend. and on November 5th, have set aside for the Hawaii Island Land Trust matter. On November 18th, Palama Lanai, and November 19th, Palama Lanai. On December 2nd, we have, if we have any remaining matters with Palama Lanai, that will be heard. If not, we will also have the Windward Hotel matter, Maui matter. And on December 3rd, Barry Trust matter will be taken up. December 16th, the church matter will be taken up. And on December 17th, we will, assuming the December 3rd goes well, we will once again take up the Barry Trust matter to adopt the order. And that takes us to the end of December. I would caution the commissioners that we are getting matters scheduled for January, but that has not been set yet, but we would request that you keep those dates open. Thank you.
Okay. Thank you, Dan. Are there any questions for Dan, commissioners?
Are these all Zoom meetings except for the HCPO?
We're not sure about that yet. There is some uncertainty as to whether or not the exemptions that allow us to hold these Zoom meetings will continue to be contained in the governor's emergency proclamation. We won't know until the end of this month as to whether that happens or not. We are working with the Department of the Attorney General to maintain those exemptions, but we're not sure if that will occur.
Any follow-up, Commissioner Giovanni? Okay, thank you. Any other questions for Dan, commissioners? Commissioner Cabral?
If we have any say in it as one of the 3 people that has to travel, I think I would like to really recommend that we try and at least maintain the known ability to do the Zoom meetings through the end of the year. It'd be nice to have a set plan, because Hilo's become somewhat of a hot spot. As you see, I don't even in my office, I practically wear a mask. So anyway, I'd like to encourage that we reduce travel or exposure to that method throughout the end of the year. Thank you. Because you don't want me to come and bring it to you all.
Thank you.
Okay, thanks.
That is
Commissioner.
intent, and we're hoping, very, very much hoping that we can continue to do this through the end of the year.
Thank you, Commissioner Cabral. I think for me, the larger question is going to be, how might we move to some sort of hybrid of in-person and remote meetings when the conditions of the pandemic allow? So, anything else, commissioners, on our tentative meeting schedule? If not, our next agenda item is an action meeting on docket number A03745, HANOHANO LLC, Maui, to consider HANOHANO LLC's motion to release and modify conditions filed on August 10th, 2020, associated with its petition to amend the agricultural land use district boundary to the urban land use district for approximately 28.695 acres in Keahua, Kula, Maui, Hawaii, tax map key 22-3-11 lot 1 and 2-3-11 lot 2. Will the parties for docket number A03745 please identify yourselves for the record? You may need to enable your audio.
Good morning, Chair and Commissioners. Can you hear me?
Yes.
Thank you very much. Good morning, Chair, Commissioners, and other parties. This is Jennifer Lim representing petitioner HANOHANO LLC, and my associate Derek Simon is not on the Zoom, but he's also here with me today. And in the audience, we should have Ms. Leilani Pulmano, who is the project developer for this project, should there be questions. Good morning.
Okay. Thank you.
Good morning. Deputy Corporation Counsel Michael Hopper, representing the Maui County Department of Planning. With me are Planning Director Michelle McLean and Planner Tara Furukawa. Thank you.
Thank you.
Good morning, Chair, members of the Commission, Deputy Attorney General Dawn Apuna on behalf of the State Office of Planning.
Thank you, Ms. Apuna. Let me update the record. From August 10th through September 30th of 2020, the Commission received the following documents: HANOHANO LLC's motion to release and modify conditions, HANOHANO LLC's Exhibits 1 through 27, requests for an extension of time to respond from the Office of Planning and the County of Maui, which the Land Use Commission approved, the County of Maui's original and revised position statement, the Office of Planning's response to HANOHANO LLC's motion to release and modify conditions, as well as their Exhibit 1, HANOHANO LLC's second list of exhibits, and Exhibits 28 through 31. Sorry, somebody was not muted. On September 28th, the Commission mailed the October 7th through 8th, 2020 notice of agenda to the parties and to the statewide Oahu and Maui regular and email mailing lists. Now let me briefly go over our procedures for today's docket. First, I will give the opportunity for the petitioner to comment on the Commission's policy governing reimbursement of hearing expenses. I will then call on any individuals desiring to give public testimony to identify themselves. First, beginning with folks who have registered beforehand to testify, followed by anyone in the audience who may wish to testify. They will signify by raising their hands using the raise your hand function in Zoom. After the completion of public testimony, the petitioner will make their presentation. After the completion of the petitioner's presentation, commissioners will ask questions. And after the commissioner's questioning, we will conduct our deliberations. Are there any questions for our procedures today?
None from petitioner.
No questions, Mr. Chair.
Thank you.
No questions.
Okay. And from time to time, approximately for 10 minutes every hour, we will take breaks. So Ms. Lim, have you reviewed HAR 151545-1 with regard to the reimbursement of hearing expenses?
We're familiar with the Commission's policy on reimbursement, and the petitioner will comply with that.
Thank you. Okay, is there anyone in the audience who wishes to provide public testimony on this matter today? If so, use the raise your hand function because nobody has previously registered or submitted testimony on this matter. If you use the raise your hand function, I will promote you to be into the main part of the meeting and swear you in. Seeing none, public testimony is closed on this matter, and Ms. Lim, you can begin with your presentation.
Thank you.
If you want to give us an overview of how long you expect to take, that would be useful.
I would say perhaps 15 minutes. Perhaps even more quickly. And it depends, of course, always on the nature of the
Ms. Lim, there is a lot of background noise in wherever you are physically. I don't know if we're picking up traffic noise or if it's, are you using a wireless earpiece by chance?
I am using wireless because I'm in an otherwise pretty silent room.
Chair, this is Jean, the court reporter.
Yes.
I'm also having difficulty listening to Ms. Lim with the background noise. I can't catch every word.
Yeah.
Oh.
It sounds as if your window is open and we're hearing the city buses go by.
I'm so sorry because there's actually no background noise.
Do you have the ability to use your built-in microphone or a wired mic?
Let me see. Excuse me for a moment. Okay, does this sound better?
No.
I'm very sorry. Everybody's time is precious. May I ask for a 3-minute recess while I try to find some headphones that I can plug into the computer?
3-minute recess at the discretion of the chair.
Okay.
Commissioner Cabral is here. Ms. Lim, you may proceed.
Thank you, Chair. Thank you, commissioners and other parties. As I said, I'm Jennifer Lim, and I'm representing the petitioner HANOHANO LLC. And you've seen me, several of you have seen me here before, and there's been different levels of complexity with matters that I've brought before the commission. I think sincerely that this should quite without question be the most simple matter that I have ever had the pleasure to bring before this commission, and here's why. HANOHANO LLC
had a petition for district boundary amendment back in the mid-2000s. As Chair Scheuer explained, a decision and order was issued by the commission that was actually issued on May 17, 2005, and it reclassified, the commission approved the reclassification of just under 29 acres in upcountry Maui from agricultural to urban for residential development. The commission did that subject to 26 conditions of approval. We filed a motion in August because the developer has completed the development of the property. All of the conditions have been met. There are a couple of conditions that are more of an ongoing nature. So those, of course, have been satisfied and would continue to be satisfied in the future. But of the 26 conditions that the commission imposed back in 2005, as I said, 22 of them have been completely satisfied, and we've filed several exhibits, as Chair Scheuer mentioned, to provide the commission evidence of that satisfaction. 2 conditions we're not requesting a release of because, I'll explain it in a moment, but one of those conditions prohibits development of Ohana housing. And the other condition that we're not seeking release of is the condition that basically articulates what's in the commission's rules about allowing, petitioners, whatever, that may mean in the context, allowing them to seek release from the commission of an outstanding condition. So we looked at those sort of as hand in glove. We're not requesting release of the Ohana condition. And at the same time, because this property has been, as I said, fully developed, there's people living on the lots, there's a community there right now, they may want to seek a release of that Ohana prohibition in the future. So therefore we said, let's just leave the 2 of them there. And if the HOA or other property owners within the project wish to release the Ohana condition, then they would have that vehicle through the commission. And then there are 2 conditions. So again, we've got 22, we have 26 conditions in total. 22 have been completely satisfied. 2 conditions we're not seeking to release or amend whatsoever for the reasons I just explained. And 2 conditions we are seeking some amendments to. And this is all presented in our motion, but I'll just give a quick summary. The one condition that we're seeking amendment to is a very long, it's a multi-part condition having to do with, I believe the heading of the condition is, archaeological resources or historic and archaeological resources, but it's a multi-part condition. And the concerns were about sort of cultural monitoring in light of the fact that there's a heiau site within this project. And we're not seeking a release of that multi-part condition. I believe it runs from like 4A, it's condition for 4A down to like 4G or something. So there's several parts to it, but we are requesting some tweaks to the condition that I can explain in more detail if the commission would like. But the reason for the tweaks is that there are certain very specific items that the commission imposed in 2005 that we found to be unworkable. None of the unworkability has to do with the spirit or intent of the condition, but there's just some technical compliance issues. So we wouldn't be, to be quite transparent and to know that the people who are living at this community would, I'm sure, want to maintain compliance with the commission's orders as well. We're just seeking a few minor amendments within that condition to make it something that is workable on an ongoing basis, should that be the commission's pleasure. And then finally, there's a condition that requires all petitioners, to record conditions after the commission issues an order. And when this decision and order got issued in 2005, that kind of condition was imposed. And we would imagine that if the commission's ultimate pleasure is to release some conditions, modify the 2 that we're asking, whatever that may be, we would just want to amend and restate the existing recorded conditions to reflect whatever the commission's ultimate decision is today. So that's a quick summary. As I said, Leilani Pulmano, who is the project manager and who has been involved in this property for many years, should be in the audience if there's specific questions that the commissioners have about the project. But it's a terrific. I mean, it's a modest but quite a beautiful project. And there's 49 residential lots. As I said, they've all been sold to third parties. I believe, at least at the point that we filed our motion, at least half of them, I believe, were occupied by homes. Ms. Pulmano may have a further update on that. But there's 49 residential lots. There's a Heiau retention basin lot. That's called lot 50. That's where there's, again, particular measures that the commission has imposed and that the developer has adhered to and the HOA would continue to adhere to through various means, including the declaration of CC&Rs that the developer recorded against the property, after the commission's approval, certain bylaws that established a curator selection committee, which was a requirement of the Land Use Commission. So those things would go forward. The Heiau retention basin lot is designated on the file plan. It's identified in a preservation plan. There's absolutely, it's got a beautiful rock wall around it. I mean, there's absolutely no question that that will be maintained. And then there's a couple of common area lots, which are roadway lots, which I don't think we need to talk about, but of course, any questions are welcome. Those have been conveyed, dedicated by the developer to the homeowners association. There's a lot that has been conveyed to the county of Maui, and then there's a small roadway widening, a roadway piece that is in the process of being conveyed to the State Department of Transportation. So why are we doing this? Because, I mean, you folks have seen lots of projects, you've approved several projects, and not very many people come forward to say, hey, give us a clean bill of health, we're done here. And again, Ms. Pulmano may want to supplement what I say, but what HANOHANO was thinking is, okay, they're part of the Maui community. They've built this project. Some of the people who bought lots are people who are, friends or business contacts or, colleagues of the developer HANOHANO. And before they completed the turnover, meaning before HANOHANO as a developer completed the turnover to the HOA, which is, I mean, on the cusp of being completed, as I said, land has already been turned over to the HOA. HANOHANO said, look, we just want to give the HOA, for lack of a better term, a clean slate, confidence that the conditions have been met, so that the HOA understands what may be outstanding and what may not be. And again, in our perspective, there's nothing really outstanding. And also, so the HOA wouldn't be burdened with, I mean, I hate to describe it as a burden, but those annual reports that, petitioners are always told to file. HANOHANO has tried to be very compliant with that. At this point, with a project that's fully built out, it seemed like a sort of an unnecessary burden to put on an HOA to report back to the poor Land Use Commission staff, who I assume has to read these reports year in and year out. This is done, this is done, this is done. So it was a combination of wanting to give the HOA a crystal clear understanding of where the project is in terms of Land Use Commission compliance, and try to make things more simple for the HOA going forward. So with that, I'll stop and see if there are any questions or if there's any supplement that you'd like to hear from Ms. Pulmano.
Thank you, Ms. Lim. Commissioners, are there questions for the petitioner? Commissioner Okuda.
Thank you, Mr. Chair. Ms. Lim, the Office of Planning filed a pleading, and I'm just going to read one sentence, and I'm going to ask you whether or not what the Office of Planning was proposing is acceptable. And let me quote, this is the last sentence in their pleading. For purposes of efficiency, OP recommends that LUC defer the release of Condition 6E until the dedication of the ROW and setback has been completed to DOT satisfaction, and that the Commission authorize the LUC Chair to order the release of Condition 6E once evidence of the completion of the land dedication has been submitted to the LUC. if the commission were to approve your request with that additional statement suggested by the Office of Planning, would that be acceptable to you or your client? And that's my only question, Mr. Chair. Thank you.
Thank you, Commissioner Okuda. Ms. Lim.
Thank you very much for the question. So just to reflect back, if the commission were to take action today and conditionally say that once the commission's executive officer received evidence of the completion of the dedication, that one part of condition 6 would be released. You know, if that's the commission's pleasure, I do want to say, because I don't want this commission to have any misunderstanding about the diligence with which HANOHANO has pursued that, you know, creation of that road widening lot, the pursuit of having the property, you know, properly surveyed, preparation of the dedication deed. I mean, HANOHANO is prepared to sign a dedication deed like today. You can see in the record, I think it's our exhibit, it's our exhibit 29, which is an email chain from Ms. Pulmano to some folks at Department of Transportation starting back in October of 2019, saying, you know, hey, we're ready to dedicate, what do you need? And then, okay, well, here's a property description. Well, okay, here's the deed. And I understand it's just a process, you know. My understanding, and I've never worked for the Department of the Attorney General, is that the deed will have to go back to the land board and for their deputy AG possibly to review the language before it then goes back to the director of DOT to sign, before it goes back to Suzanne Case to sign. And that's because the dedication is actually to the state DLNR. And I do point in the record that in, what was it, August 14th, the land board did approve acceptance of the dedication. So really to us, we feel like it's just a very ministerial matter, and our client is prepared to sign the deed right now. So again, I don't think it's unreasonable if the commission has sort of a contingent release on that. We of course just wouldn't want to A, leave this commission with the wrong impression, or B, require anybody to come back before the commission to evidence something as ministerial at this point as just a signed dedication deed. We are trying to make things simple for the HOA and not bring them back before the commission.
Thank you, Commissioner Okuda, for your question and for your response. Commissioner Ohigashi.
I was concerned about condition number 4 and its various subparts. Can you explain to me how would your modifications work with the 3-member curator selection committee? How would that exactly work? Who would be on it? Because maybe I'm just in space today, but it's when I was reading it earlier yesterday or the day before, I couldn't imagine it or see it. Can you explain how it works?
Thank you, Commissioner Ohigashi. That's a terrific question. So when the commission approved the district boundary amendment back in 2005, one of the requirements was to establish a curator selection committee. And as I said, that has been established, but and it was a 3-person committee. But here's the issue that we've had with that. The condition itself said that there will be a 3-person committee, and it'll be comprised of somebody from the HOA, a representative from OHA, and one from the Kupuna Council. And what has become problematic is that the Kupuna Council no longer exists. And what's become further problematic is, although the curator selection committee process has coordinated with OHA, OHA doesn't in fact have they don't have a mechanism to actually participate in the curator selection committee. So the change that we're requesting is, again, to maintain a curator selection committee, but to update the makeup of that committee to make it something that can actually be complied with. So our request is that the Curator Selection Committee, I'm just going to call that the CSC, will have 2 members from the HOA, 1 member from either Hawaiian Civic Club or the Ahumoku Council or another similar Hawaiian entity, because again, we're trying to maintain what we believe were the concerns and the intent of the commission, but trying to actually make it feasible since the entities that the commission had originally identified are not able to participate, and one of them doesn't even exist. And in addition, so it would still be a 3-person committee, and in addition, this Curator Selection Committee would seek input from Office of Hawaiian Affairs. And Ms. Pomano actually just very recently did contact Office of Hawaiian Affairs, as you all probably know from the Office of Planning's filings. They had not gotten feedback from Office of Hawaiian Affairs, but Ms. Pomano did speak to Office of Hawaiian Affairs just this past week. And again, if she raises her hand, I'm sure she would be able to explain to the commission the basic premise of that conversation. But they did indicate that they were willing to play sort of a review role, but they wouldn't be a member of the Curator Selection Committee. So that's essentially it, Commissioner Ohigashi. It's just, like I said, one of those entities that the commission imposed in 2005 doesn't even exist. OHA doesn't have a process or means by which it would be a member of the committee, but we still anticipate that they should have let's say, an advisory or a consultation role on this committee, and we would have 2 members of the HOA.
Well, I noticed the original requirement was that only 1 member be of the HOA, and there be 2 sort of outside members. Would the addition of an additional member to the HOA have a bearing on how they make decisions and sort of like take out the non-party type of representative under condition number 4? Well, that was the balance that was established in that condition number 4.
That's a very fair question. I mean, certainly that's not the intent whatsoever. As I said, we're trying to find a way to replace what the commission has imposed as the Kupuna Council no longer exists. So we just can't have that. We need a replacement entity. And as I said, OHA in a consultation role would, because OHA won't actually participate as a member of the Cultural Curator Selection Committee. I think that between OHA and the appropriate Native Hawaiian organization that would actually be a member of the committee, and the fact that people who purchased into this project and are therefore members of the HOA did so fully informed about the existence of the heiau, very well aware of it. It is recorded into their property documents. I would not imagine there would be a shift in the balance of power. And again, the exhibits show that the heiau lot has been extremely well maintained. So I don't think that would be something. There couldn't be a change, any sort of significant change to the way that the heiau lot is maintained currently.
The last question I have on this particular area, I might have more later on, but the Kupuna Council of Maui is a county entity.
Commissioner Ohigashi, I have to confess my ignorance on that, and perhaps the county can opine, or even Ms. Pomano. And the reason why is, as I said, I understand that it's defunct. It no longer exists. And it no longer existed from the point that I had knowledge of this project.
So I'm just curious, has the petitioner take a look at any substitution type of organization that replaced the Kupuna Council of Maui, or any?
I mean, as I mentioned, we what we're proposing in the condition, and if there are other ideas coming from the commission, you know, we're here because we want to get clarity and we want to turn over to the HOA something that makes sense and is workable. The entities that we proposed in the condition were the Hawaiian Civic Club, Ahumoko Council, or another similar Hawaiian entity. Now, I know that doesn't necessarily replace whatever it was that the Kapuna Council did. And again, I have to confess my ignorance on what exactly the Kapuna Council of Maui did. You know, that was 15 years ago, and
Okay.
I'm afraid I don't know.
The last thing is, I guess the last thing is, would the curator know what exactly the purpose of the Kapuna Council of Maui participation be? Or, you know, what's the history, or why was the Kapuna Council included as a representative of, as a member of this, is it curator selection committee?
I don't know. Again, that was a requirement that was imposed by the commission in 2005, and the petitioner went ahead and, you know, prepared bylaws for the curator selection committee consistent with that, and it's just not become, it's not been feasible. I mean, the purpose of the curator is to make sure, again, we're talking about the curator selection committee. We're not talking about trying to change the need for there to be a curator. And the purpose of the curator selection committee was to select somebody who would, you know, monitor this heiau and be a curator and provide information to the curator selection committee. And one of the requirements that the commission imposed in 2005 is that there also be reporting to the Land Use Commission from the curator. And in fact, that's an element that we're requesting some modifications to. And here's the reason why. Again, the curator selection committee exists to select the curator. But then the curator is an independent person who maintains, I mean, or advises on the maintenance of the heiau. You know, and is a point of contact if there are, let's say, questions or expressions of interest about that particular lot. When the commission imposed the requirement that there be reports from the curator, I'm sure that was, well, I don't know, I wasn't there in 2005, but I'm sure that's because the commission just wanted to make sure that things were done correctly. At this point, again, because everything is built out and you can see the lot and you can see the heiau site, that, you know, everything has been done in accordance with plans, we would ask that the curator, because this, again, is just a, you know, volunteer member of the community who has an interest in matters of cultural concern, that they not be required to submit annual reports to the commission. I mean, the curator will be the curator. The curator would communicate, again, concerns or information to the curator selection committee, which could then report it to the larger HOA. But we would prefer, knowing that, you know, writing reports is cumbersome and so forth, that the curator or the curator selection committee could provide reports to the commission upon request. It's not an effort to try to dodge sharing information by any means. It's just trying to make it more practical for a, you know, a small community association.
Commissioner Higashi.
Just so the last question. Can the curator selection committee replace the curator?
So sure, yes. In fact, I mean, their role is to identify the curator, and then when a curator is either no longer interested in being in that role, relocates, cannot do it for whatever reason, then yes, there is a process where they would then select another curator. The curator that had been in place, Mr. Ka'ai, was the curator. And again, all of the landscaping has been done pursuant to the preservation plan, and with input, everything has been complied with, but the requirement is that there always be a curator. Mr. Ka'ai, we had understood had left the island. And so there's actually a gap right now on the curator. Now, luckily, some of the, both the petitioner and some of the lot owners are extremely I don't want to say savvy, but extremely sensitive to matters of this nature. So, you know, there's people are on the lookout for a curator selection, for a new curator, but without a properly constituted curator selection committee, then it's kind of hard for them to move forward. And again, properly constituted meaning, you know, changing some of the things that are impossible about the curator selection committee right now. And lo and behold, although we had understood Mr. Kai had left the island, he may in fact be back on Maui, and Ms. Pulmano is trying to make efforts to get back in touch with him. But in any event, we do want permission from the commission to, you know, officially change the composition of this selection committee, so that whether it's Mr. Kai, if he is still willing and able, or another curator can be selected.
Thank you, Ms. Lim. Commissioner Chang. Oh, sorry.
No,
You had a last.
No. I just wanted to say I don't have any more questions.
Okay, thank you, Commissioner Ohigashi. Commissioner Chang.
Yes, thank you, Chair. And good morning, Ms. Lim. I just want to follow up on some questions raised by Commissioner Ohigashi. I guess it's my understanding in reading back through the original findings of fact, it was Uncle Charlie Maxwell, who was the consultant for the developer, who put together the curatorship conditions and the program. So, and it was very thoughtfully done. So I like the Commissioner Ohigashi have concerns about just the balance. And I understand that the association has great intentions. My understanding is Leahi Hall is a landowner and is a member of the commission. Leahi comes from a family who undoubtedly is extremely sensitive, and I have no doubt she will, she accepts this kuleana and will continue to make sure that that area is taken care of. And likewise, I think you have Auntie Patty Nishiyama, who is similarly a very well-respected kupuna of the area. But these are individuals, and there are numerous entities within this area besides the Homestead Association. DHHL has a very large development in Kula. Kamehameha Schools is very nearby. In my view, it is always better to find people who are from that area, who have ancestral ties, who would be the people that would most likely accept the kuleana to malama that heiau. So I greatly appreciate Leahi Hall's participation, but in the event that she moves, I am much more comfortable given the fact that there are numerous Hawaiian organizations and relevant affiliations nearby the development, that I would feel much more comfortable if the association had one member to select. And I understand it's only a selection committee. They aren't the ones who are actually doing it. But what we decide today will have to last during the life of this subdivision. So that is my concern, that there are numerous existing entities very nearby this area that I think it would not be difficult to do a kahea or a call out to that community, especially someone from Kamehameha Schools or the Homestead Association, who I'm certain, or even Haleakala above you, would be more than willing to sit on this committee. So I too shared the concern about having two members of the association. I would prefer that it remain the composition of the committee remain the same, given the fact that there are other organizations or individuals that could be tapped into in the area. So that's my only comment about this. I think that maintains the spirit of Uncle Charlie's, his establishment of that. If Sam Ka'ai is back, that would resolve a lot of the issues as he would continue to malama the area. But I just wanted to convey that. That was my concern about your modification. I would prefer that the composition remain the same.
Ms. Chang, Commissioner Chang, were you hoping for a response or was it more of a statement?
Yeah, more of a response, because that is the petitioner's recommendation to modify and to have 2 HOA members sit on. So my request is, my inclination is to, or my ask is, would you be willing to accept that the composition of the selection committee remain the same? 1 member from the association and 2 members from the selected by Native Hawaiian organizations, for example, like, you know, the ones you've listed, and then OHA continue to oversee, but that's my ask to you. Do you have any objections to keeping the composition the same?
The ratio, I think,
Yes.
is, yeah.
Yeah.
So
Ms. Lim.
thank you very much for the questions, Commissioner Chang. Chair, may I ask Ms. Pulmano to be brought into the room?
Sure.
So she can respond to this question directly. She's been listening.
I think she's been admitted. Has she been admitted, Scott? I was looking for her and she disappeared.
Yeah, it's in the process right now. So you're going to do a sound check with her.
Okay. Ms. Pulmano, if you can enable your audio and video, which you can do once you're into the main part of the meeting. Aloha.
Aloha.
I'm going to swear you in before you respond to the questions from Commissioner Chang and any from your counsel. Do you swear from the testimony you're about to give is the truth?
Yes, I swear.
Thank you. Please continue, Ms. Lim.
Well, you know, Leilani, if I could, and it's funny to see you on video. Hi. If I could, you've heard the concerns both from Commissioner Ohigashi and then even more so from Commissioner Chang. Could you offer your response?
Sure. Thank you for that, Commissioner Ohigashi and Commissioner Chang.
Hold on. I am experiencing audio issues with Ms. Pulmano. Is anybody else? Okay.
I am.
Ms. Pulmano, I'm going to ask you to disable your video and simply go to audio, which might be more reliable.
Can you?
Ms. Pulmano, okay. If you can hear me, if you can disable your video.
My screen shows are frozen. My screen shows are frozen.
Yeah, mine. Thank you, Commissioner Ohigashi. Mine does as well. Ms. Lim, are you able to text her?
Yes.
Okay. Another tip I have learned is that if you're not hardwired for your internet connection, no matter how good your broadband wireless is, it's not super reliable. Ms. Pulmano, can you hear me now?
Sorry.
Can you hear me now? Sorry, can you hear me now, Ms. Pulmano?
Yes, I can.
Okay. Your connection is still not robust, but let's try.
Okay. Can you hear me now?
Yes.
Okay. Great. Respond. We verification.
No. Ms. Lim, this is, sorry. Ms. Lim, we're not picking up the audio on this, unfortunately.
I understand.
Chair?
Commissioner Chang.
Yeah, and perhaps Ms. Lim can talk to Ms. Pulmano or text her during the presentation of both the county and OP's.
She's freezing up.
proposed in our amendment was have 2 members of the HOA, 1 member of a Native Hawaiian organization, and to consult with the Office of Hawaiian Affairs. And commissioners had raised, you know, obviously very valid concerns or interests in it, whether there was sort of a change in the balance of power because of the different makeup of the Cultural Selection Committee. So Ms. Pulmono, to that point, explained that the petitioner's thinking was sort of twofold. One, all of the buyers in this project are local buyers, and I think the commissioners know that anyway, but it's not a resort development. It's local buyers who, as I said before, bought in knowing about the importance of this property. Secondly, the second HOA member who has been identified is actually works for Kamehameha Schools as a teacher. His name is Kahuna Noah. And so he would be the second HOA member along with Ms. Leilani Hall, as Commissioner Chang mentioned earlier. And that said, and again, to Commissioner Chang's point, you know, excuse me, did I say Leilani Hall? Ms. Hall is extremely well equipped to be in a role like that. But homeowners can change over the course of time. So if the commission believes that the composition should be still 1 HOA member and 2 members from, you know, maybe yet to be identified Native Hawaiian sort of organizations, along the lines of what Commissioner Chang said, that would be fine.
Thank you, Ms. Lim. I want to check. I saw that the OP in Maui faded in and out. Were you still having connection problems during Ms. Lim's response? Mr. Hopper or Ms. Apuna?
Mr. Hopper's on mute.
We don't get, so we can at least hear the meeting. Can you hear us okay?
We can hear you.
Okay, yeah, we're gonna do the audio through the phone in case we get kicked off, but yeah, we're on and off like several other parties.
Okay, Ms. Apuna?
This is Dawn Apuna. I got maybe half of that.
Okay. I'm just going to acknowledge as the chair, I can see the number of participants in the meeting shifting very frequently. Track to see whether commissioners at any given time, or if some of my commissioners or the parties who are essential to this proceeding are participating. I'd like to ask Mr. Ordanker and the folks at the LUC office whether or not we might consider recessing until 1 p.m. to see if these technical issues can be resolved, because right now this is not a productive use of our time, and I'm not sure that we're meeting the requirements even under our COVID orders.
Yes, we're still experiencing technical problems. Seems like with our cloud server from our originating locations.
Okay, so
I think we're agree that.
Okay. Ms. Lim, Ms. Apuna, and Mr. Hopper, my suggestion is going to be that we recess and reconvene in 2 hours to see whether or not that's enough time for the staff to figure out what's going on and for us to resolve issues. But I don't think that it's going to be a productive use of anyone's time to try and do this live. Starting with Ms. Lim.
Petitioner doesn't have any objections. I mean, we agree that this very disjointed hearing process isn't doing anybody a good service.
Mr. Hopper.
Let us know what time before logging off, then we can log back in then.
We would reconvene at 12:30 per my suggestion.
12:30. I'm available, and yes,
12:30
the other
PM.
party, the other.
Ms. Apuna. or commissioners? Any concerns? Commissioner Ohigashi.
I just want to know if we should stay on or
My suggestion would be to log off
Then
and plan to log back in a little before, maybe 12:15 or so, with the aim to start at 12:30.
Don. OP, can you unmute?
I only heard I was trying to listen through my, through Lorraine, but I only heard like the last 15 seconds. I heard
The suggestion
12:15.
is that we log on at log off now, log on at 12:15, try to reconvene proceedings at 12:30 if the technical issues can be overcome. Is that acceptable? Okay, thumbs up from OP. Thumbs up from any commissioners or thumbs down with anybody with concerns?
Mr. Chair, like Commissioner Giovanni, I have to leave by 4 o'clock.
Okay, yeah, we are, I'm trying on the fly to figure out, give us enough time to see if we can resolve this problem, but not so much time that we're unable to complete our business. Sorry, Mr. Lau, is that okay? Okay. Okay, we're going to recess until 12:30 p.m. This is for the audience too. Audience members, the meeting itself might shut down and restart. Plan to log on at 12:15 p.m. and reconvene proceedings at 12:30.
Mr. Chair, we were using the same link, right?
Same link.
That had caught your attention.
yeah, notification of prospective buyers about the, I think it was a,
Right to farm.
yeah, the right to farm.
Right. And so again, that's a situation where when the subdivision got registered, that was a notification that was in the public offering statement. We have in our record, we just provided one lot deed. We didn't want to provide you all 49 lot deeds. These are for the residential lots, but that's Exhibit 21, and that has that language in it. And that language is also in the CC&Rs. So there are several places where buyers, should a new buyer come in from California and want to buy a lot here, there are several items that'll show on title to put them on notice of that particular Right to Farm Act.
So let's say that, I just give you an example. Let's say that we decide, well, the CC and Rs are sufficient. Is there any kind of problem or difficulty that the petitioner, that your client has with regard to having an overlay of these conditions? In other words, it seems to be what you're saying is that, yeah, we're all protected under these two other mechanisms. So I'm just trying to say, why would we want to reduce the amount of conditions in those areas? And how does it affect the petitioner, and to what detriment does it? Yeah.
I think I understand. I'm going to try to respond, and then Ms. Pulmano can supplement if that's okay with the commission. I mean, for certain conditions, like the one that we were just discussing, Commissioner Ohigashi, about notification of potential nuisances, I mean, granted, if it's already documented in other places, or a condition that's already embodied in state law, if those things are already documented in other places, then what's the harm having yet another encumbrance on the property imposed by another body? So I guess you could say, well, there's not really an additional problem. If we come back to what is the point and the purpose of us filing this motion, it was to try to turn over to the HOA a tidy package, assurance that the conditions have been met. These are the conditions that are ongoing, and so that they know how to comply, so that they don't have to, and then also so they don't have to continue to submit annual reports. And you know, frankly, I mean, that's an expense of time and money, both for HOA members and for commission staff. It won't do anything extra by having it continue to be an encumbrance pursuant to an LUC declaration, but it certainly doesn't enhance the security. And in fact, I mean, You could even say, well, what is the validity of conditions after a project is fully built anyway? Doesn't really enforcement fall to the county and not to the Land Use Commission, you know, under Chapter 205? So it's almost like when a project is completed and somebody can come and show you evidence of that, you know, wouldn't the commission want to say, yes, our job is done here, and now, you know, we turn it to the county to deal with whatever enforcements. And we're very grateful that the county, and we had discussions with the county, and we were very grateful that the county provided statements essentially in full support of, although of course Mike or Ms. McLean can modify that if I didn't phrase it quite right. But so it's more like a, let's just put an end, you know, cut things off, make it very clear what the HOA has to do. That's the goal. And Leilani, is there anything that you would care to add?
Sure. I would add that in my experience of selling these lots, only one person asked about the LUC conditions, and everyone else asked about all of the CCNR requirements. And that one person was an attorney general working for the state at the time. So she's very, very thorough. But just from my experience is that lot owners basically pay much more attention to the CCNRs and those types of documents than a document that's embedded in their title, especially the Land Use Commission list of conditions. So it's really just about practicality.
Would it be correct to say that the CCNRs may be amended by the HOA?
The CCNRs may be amended, and I don't have this immediately at my fingertips, but I believe it probably requires a 75% vote of the total membership.
It's a 67%. Just
is it 67? Thank you.
So there may be conditions, for example, like the you can't build a second dwelling, and that I don't think we're being asked to remove that condition. But if that condition was removed, the CCNRs would, that based on that condition, can be amended to say, yeah, you can build a second dwelling. Is that right?
Yeah, that's correct. I mean, whatever the Land Use Commission does or doesn't do today, if it's contrary to what's in the CCNRs, the homeowners would not have any ability to take action. They would have to, of course, adhere to whatever the project governing documents are.
Yeah. The sad thing about me is this: is that I'm a lawyer who does a lot of family law, and I believe that it sometimes I've seen things go really, really wrong when things are left up to the parties to make a decision upon without that guidance that is in there. So, and I know that I know that things are going well, that the intent of the homeowners now are compliance, the CCNRs are in compliance. But I'm just that type to say that, well, we still have the framework. At least we know that if the people change, the project won't. And that's where I'm coming from. So if you can identify specific harm that you may have, I'd be glad to take a look at some of the changes. And I think there's an agreement with a lot of the conditions, but I was just looking at those conditions that appear to me to have some kind of relationship back to some or basis or reasoning to say that, don't worry, this is protected by the CCNRs. So that's a comment, or that's a question. That's a question you may want to answer if you can do it or if you cannot do it.
Commissioner Cabral has still
As
been
I'm-
waiting to ask a question, but if Ms. Lim, you had a brief response.
You know, things got a little, that weird echoey sound at the end of what Commissioner Ohigashi said. I believe what I heard you say, but it got a kind of echoey is if there's information in the CC&Rs that document that the intentions of the commission have been articulated in the CC&Rs, that you would like me to call attention to that, but I'm sorry if I misheard you.
No,
Commissioner Ohigashi.
It was more of a comment. And what I wanted to say was this, is that I see the conditions as general rules or a skeleton or a framework as to what should be required. And what you've indicated to me is that the CC&Rs have implemented a lot of these conditions that you want to essentially say was satisfied, even though there may be some ongoing requirements. What I'm saying is that if you can show me the harm in getting rid of them, I would be glad to consider that. But hopefully I like to keep the framework so that we understand what is going forward is part of this framework, and that if the people change, develop the CC&Rs or implementing the CC&Rs, if the people change, the framework remains the same. And that's what I was trying to get at. You understand? You heard me.
I do. Yeah, I mean, I do come back to, again, yes, CC&Rs can change. I mean, the CC&Rs, the bylaws, the entire project was built to be consistent with what the Land Use Commission imposed in 2005. Everybody who was bought in there with an awareness, as Leilani said, that the first thing they're looking at is not Land Use Commission recorded declaration. They're looking at their CC&Rs, they're looking at their deed, they're, you know, the things that most of us, except for maybe very diligent attorneys, would be looking at. But what was required has been accomplished. And as I said, at this point, the desire was to be able to give the homeowners association a sense of assurance and clarity on what they need to comply with, what additional Land Use Commission matters might be of an ongoing nature, since really everything except for the couple that we've identified as having some ongoing requirements have been satisfied. If the project were to change, you know, entirely, a whole different crop of homeowners would come in. The Land Use Commission's ability to take action on that is limited, if non-existent altogether, right? Because the Land Use Commission's abilities to, let's say, reel in property owners really comes down to before there's been substantial commencement. This project is totally built out. So it's, like I said, this is a formality, but it was an important formality for the petitioner because they did want to be able to give as much clarity as they could to the homeowners association. I don't know if that fully responds to you, Commissioner Ohigashi.
I just wanted to also briefly do an audio check. Ms. Lim, you indicated you were receiving some echo. I've had excellent audio quality from everybody. Is there anybody else experiencing any audio problems at this point? Okay, thank you. Commissioner Cabral, thank you for your patience.
Yeah, thank you very much. Some of my questions have been somewhat answered in the last conversations, but I think I want to get really good clarification. So Attorney Lim, can you verify that my assumptions are correct, that when you come to CC&Rs for subdivisions, that the enforcement of those can be made by the homeowners association, their board of directors, as well as by any of the individuals in the homeowners association, as well as through any type of court action, even from an outside member from that homeowners association, if they felt like there's a violation of some sort, particularly if it involved violation of one of the things connected to a state or county law, as well as through, so it could be enforced through the courts, as well as the county could move for enforcement, or the state could move for enforcement if they were so violated. Am I correct in understanding it that way?
You know, Commissioner Cabral, that's really beyond the scope of, I'm sorry to disappoint you, it's really beyond the scope of what I would be here to talk about. I mean, the CCNRs set forth, you know, who can enforce them and how they can be enforced. I mean, CCNRs also, you know, do have the ability to get amended by the requisite votes, which Ms. Pulmano corrected me is 67 and not 75, as I've seen in certain CCNRs. You know, to what extent people can seek to enforce them who are outside of the actual coverage of the CCNRs, I'm not going to be able to comment on that.
Okay. Well, I'm trying to give information to my fellow commissioners because that's what I do for a living is manage subdivision associations. And they are very, CCNRs, I mean, I think my understanding is what we're trying to do, or you're trying to do, is take this subdivision and remove these conditions so that the subdivision homeowners association has a clear guideline as to what they have to deal with. As long as the LUC conditions on it, they have that set of conditions, plus they have their CCNR conditions, as well as potentially any other ordinances that come through the county. And having been involved with CCNR enforcements, as well as through the courts as a master receiver for large subdivisions, it is very convoluted to have various governing documents. I very strongly support the intention here of relieving the LUC of its these conditions, so the LUC can no longer have to be having this subdivision in its portfolio, and letting the homeowners association take on a good document with CCNRs, because I will tell you they are very strongly enforceable by the association as well as by members out in the subdivision as well as outside of it, and through court action. So I agree with the concept of trying to get these cleaned up. And in regards to, initially my question was regarding number 4 with the archaeological sites. I have other CCNRs where it names that I have to deal with a certain entity. And then that entity, because I've got a subdivision I manage that is 70 years old, was here before statehood. So, wow, how wonderful it names an entity that hasn't existed for 60 years. So it would be nicer if we could, instead of naming which organization is going to oversee the selection of the overseers of the Heiau, to have some kind of other fluid organizational body that, or at least have the language allow for it to be this organization or something similar to, because you can get really stuck in when they're exactly something that no longer exists. So I don't know that there's a county agency that exists that could be named to be something to help select the oversee the Heiau or not, but I would try and get away from non-official organizations to be part of the decision making. So that's just my 2 cents. Thank you.
Thank you, Commissioner Cabral. Commissioners, are there further questions for Ms. Lim at this time? Seeing none, I'm just going to state for the record, when I went over our procedures for this docket this morning, I did not indicate that the county and OP would have a chance to present, but I intended to. We now will move on to the county.
Thank you, Mr. Chair. Can you hear me okay?
We can. Thank you, Mr. Hopper.
Okay, hopefully we can get through the entire discussion. So the County of Maui has filed a position statement in this docket. I don't want to go over every single condition in our position. And Planning Director Michelle McLean's here if you have follow-up questions as well, and may be able to help answer some of those questions. But I think the conditions sort of fall into several different categories for the county. First, there are a variety of conditions. The county supports the removal of the conditions. Those would be conditions 1, 3, 5, 6, and 7, 9 through 13, 16 and 17, 21 and 22 and 25. And that's set forth in our position statement. And those conditions, the county supports the removal of those conditions or the deletion of those conditions. With respect to there's another class of conditions that the county does not take a position on removal, but does note for the record that they appear that they may be intended to run with the land in perpetuity. These are conditions number 8, 14 for BMPs during and post construction, condition 15 with respect to water conservation, conditions 18 and 19 which refer to agricultural nuisances in Hawaii Right to Farm Act, which are actually conditions that I think are required by statute to be on the decision and order, and condition 23, which is the annual report filing condition. These appear to be conditions that were intended to be perpetual, and I think Commissioner Ohigashi noted that it may be a good thing that they're contained in CC&R documents, but those documents can be amended. And if you would delete those conditions from your decision and order, and then they were deleted from the CC&Rs, then I'm not certain if there would be any ongoing obligation of the property owners to abide by them. So I think the question for the commission is, are these conditions that you intend to run with the land perpetually, or are they like some of the other conditions that you do look at them as being a date where they would be fulfilled and then could be released? So the county, again, doesn't take a position on those conditions, but would leave it to the commission to determine if it believes these are conditions that it's comfortable leaving in the CC&Rs only and deleting from the DNO, or would rather leave in the DNO. And again, with respect to enforcement, well, let me go through the last couple of conditions, and then I'll try to touch briefly on enforcement authority. One condition, condition 2, is intended to stay. The county just wanted to note for the record that it would support removing the condition. That's the condition that deals with disallowing Ohana units in the project district or in the project area. The county, I think, planning department takes the position that allowing for Ohana units can allow for a increased variety of housing types. So if there were to be a motion in the future to release that, the county believes that's something that the commission may want to consider. The other issue would be if that leads to increased traffic and additional mitigation would be needed. So we understand why that's not being requested to be released, but the county just wants to note that if you do allow Ohana units, that's one way of allowing for increased housing opportunities. And then the county does not support the deletion of condition number 20. Condition number 20 deals with access to the property from Native Hawaiians who are exercising gathering rights. The condition states the access rights of Native Hawaiians who customarily and traditionally have used the property for access on site or to other areas for subsistence, cultural, and religious practices shall be preserved. We understand that there apparently have not been requests for such access and that provisions related to this are in the CC&Rs, but the county does believe this was a condition that the commission had intended to remain in perpetuity. So it does not support the deletion of that condition. With respect to the modifications of condition 4, the county does recognize that if there's an entity that's listed specifically and they no longer exist and can no longer provide a member, that it's appropriate to amend that condition. We would leave it up to the commission as far as the adequacy of the protections remaining in the condition, but the county does recognize that there would be a necessity for amendment of that condition if it's impossible to fulfill for the reasons that have been provided by the petitioner. And then as far as the deletion of the modification to, I think it was condition 26, it does make sense that if the conditions are modified, then a subsequent filing of the modified conditions would need to be recorded on the property. So that makes sense to the county. And with respect to enforcement, I think it is important to note that from time to time, the commission does place conditions that I think are intended to run with the land in perpetuity. And I think those conditions are still enforceable, even if maybe they would not result in a reversion of the property back to agriculture. There are the options for fines or judicial enforcement. The county could bring a petition for declaratory ruling before you. in order to clarify if conditions are being violated or not. And so I think that that's something that in general, the commission, I think through county enforcement can still have access to, those conditions can still be enforced, and would not want to generally say that if there's been commencement of the building of a project, that there's no longer any ability to enforce conditions, because that would lead to some problematic results with respect to commission dockets. And again, with respect to this project, the county has no evidence that there's any violation of these conditions, and doesn't want to suggest that there are problems with anything on this property. And in fact, I think in doing the review, the conditions are all in compliance. Just the issue would be, as we move forward, whether it's appropriate to have the conditions totally released from the record and only contained in the CCNRs, or to have some of them remain as decision and order conditions that are recorded on the property separately. That's all that we have for now. But again, I or Director Michelle McLean can be available for questions.
Thank you, Mr. Hopper, for that really detailed, excellent review of your points. Commissioners, questions for Mr. Hopper. Commissioner Okuda.
Thank you very much, Mr. Chair. Mr. Hopper, if I can ask you a pass the buck question. If the association's business reason is, and I can appreciate it, that they don't want to year after year after year after year spend money to present annual reports, would it be acceptable to the county if maybe that requirement is deleted, the requirement to present annual reports, and we kind of pass the buck to you at the county to keep an eye on everything else? Would that be acceptable? In other words, we don't delete any of the conditions except to the extent it is a condition, the requirement to file annual reports. And we leave the overview and watching out for things, especially cultural resources and cultural access. We leave it to you at the county, or maybe individuals who might bring separate enforcement actions.
Well, if you do delete a fair amount, I'm not sure what's going to happen, but if you do delete a fair amount of conditions, then it would appear the reports wouldn't be necessarily very burdensome to provide. The only concern I think would be that the county oftentimes learns about compliance through the annual reports. It's something that provides those updates. Ultimately, it's up to the commission, but I think that if a good number of these conditions are deleted, then it would appear to be less burdensome for the association to provide those reports. But I do think that's up to the commission. But again, the county doesn't necessarily learn about enforcement issues without an annual report. It can get complaints, obviously, most likely probably from homeowners, but maybe from other sources. But that's one of the sources that the county does rely on. But if the commission decides it's burdensome, that's within your purview. But again, if there's going to be a fair number of conditions deleted, it would appear to be less burdensome than right now.
Thank you very much. Thank you, Mr. Chair.
Thank you, Commissioner Okuda. Commissioners, are there further questions for the county? Commissioner Axon, followed by Commissioner Ohigashi. Commissioner Axon, you're muted. There you
Thank
go.
you, Mr. Chair, and good afternoon, Mr. Hopper. Just a quick question. As we all know, and Ms. Lim kind of alluded to, that the Land Use Commission doesn't really have that much enforcement power on this one because of the substantial completion. So the enforcement responsibility kind of thrown down to the county. Is the county prepared to enforce all those conditions?
I can have Director Michelle McLean answer, as her department would be responsible for the enforcement.
Aloha, Chair.
Aloha, Michelle. Do you swear or affirm the testimony you're about to give is the truth?
I do.
Please continue.
Thank you for the question. Yes, the county has assumed the enforcement responsibility for Land Use Commission conditions. We haven't always done a great job of that in the past, but we do find that to be our responsibility, and yes, we are prepared to do so.
Thank you, Ms. McLean. Thank you, Mr. Chair. That's all I
Thank you.
have.
Thank you very much. Commissioner Ohigashi.
Hold on. I was when Mr. Harper indicated about condition number 26. I tried to look at what was condition number 26. Condition number 26 was about the report recommendation of conditions. What specifically, can you clarify to me what your position is on condition number 26?
Let me double check the report, but I believe that it was, we support the proposed modification.
Not sure. The condition number 26, petitioner shall record the conditions with the Bureau of Conveyances of the state of Hawaii pursuant to 1592 Hawaii administrative rules. And I'm not sure what the modification of that is.
Well,
is to record the remaining conditions
Yeah.
after the commission.
Yeah.
Essentially, I believe it would be to, once you, it's pretty ministerial, but if you agree to the modifications and the petitioner can clarify this, what would happen would be there would be a subsequent filing of an amended and restated declaration of conditions that would supersede the previous recorded conditions and say, these are the conditions that would run with the land. So, I mean, that would be out of necessity, I believe. But should you agree to modify the conditions, then the remaining conditions would be recorded in a document that would be an amended and restated declaration of conditions that would supersede the previous ones, and that would be the document that gives record notice to future homeowners.
So removing condition 26 has would be no problem. Since if I read their petition it was fully satisfied.
Well, I don't think let me check their motion again and perhaps, yeah. Commissioner 26 does not appear to be one of the conditions that's requested to be released. It says, request limited modifications to conditions numbers 4 and 26. And again, this is getting into the request and I don't want to misstate anything.
I just was wondering. Okay.
Are you good, Commissioner Ohigashi?
Yeah, I think I understand.
Thank you. Commissioners, are there other questions for the county? If not, we will proceed with the Office of Planning. Ms. Apuna.
Thank you, Chair. So OP has reviewed petitioner's motion to release and modify conditions and does not object to the release of condition numbers 1, 3, 5, 7 through 23, and 25 as deemed satisfied, and to the proposed modifications of numbers 4 and 26. For condition number 6, which pertains to traffic impact mitigation, OP notes that while most of the condition has been satisfied, in particular 6A through 6D, the dedication process for the right-of-way and setback along portions of lots fronting Old Haleakala Highway is still pending under 6E. DOT believes that petitioner should not be released from this obligation until the land dedication process is complete, which we expect to happen in the next few months. OP has therefore recommended, as Commissioner Okuda brought up, that the LUC defer the release of condition 6E until the dedication of the right-of-way and setback have been completed to DOT satisfaction, and that the commission authorize the chair to order the release of condition 6E once evidence of the completion of the land dedication has been submitted to the LUC. In OP and DOT's view, the alternative is to simply deny the release of condition 6E. Thank you.
Thank you, Ms. Apuna. Commissioners, are there questions for the Office of Planning? Any questions? Seeing no questions, commissioners, do you have any final comments or questions for any of the parties in this matter? Commissioners? Commissioner Ohigashi.
Jennifer, I should call you Ms. Lim. The question I have is, do you have somewhere in here language on what you want to use for condition 26?
Thank you, Commissioner Ohigashi. I was going to ask the chair's permission to offer that because we didn't articulate the precise language in our motion.
Please proceed.
Oh, excuse me. We didn't write the precise language in our motion, whereas for condition 4, we very clearly said this is the language that we would request the commission to strike. This is the language that we would ask the commission to add. But for item 26, we did not. And that's because I didn't want to anticipate erroneously what the commission's ultimate decision would be. But I will read you language, and Mr. Hopper actually reflected it pretty clearly in concept, which is that we would expect the commission to impose upon us a requirement to record an amended and restated declaration of conditions. So with that, I will read you the precise language that I have in mind as follows. Petitioner shall record in the Bureau of Conveyances of the State of Hawaii an amended and restated certificate of conditions recognizing the commission's release of conditions and modifications of conditions as order pursuant to this decision in order, whatever decision in order comes out of these proceedings, and restating the conditions reaffirmed by the commission, if any, pursuant to this decision in order. The amended and restated certificate of condition shall fully supersede and release the certificate of conditions that was recorded as document number 2005-105309. That to put it very neatly, that's how we anticipated that condition would get modified. So whatever is ultimately going to retain, the commission wants to retain or retain as modified, would be recorded through an amended and restated declaration of conditions.
Thank you, Ms. Lim.
Jennifer, would you be able to email the language to our clerk with regard to that? Because I was slow in writing.
Chair, are you asking me to do that now?
Yes.
Oh, if you can.
Mr. Chair, I believe we have that language already.
Is it on Mr. Ordenker, would you clarify where that do the parties all have that language?
Yes, I asked this is a Burt Soru Authority. I had asked Jennifer Lim about the exact same question that Commissioner Ohigashi had asked about giving us language for condition number 26, and she had emailed me that language previously. So I.
Thank you.
Just, Ms. Lim, do you have that up in front of you on your screen?
I need a moment to do that. Do you know what? I'm going to,
Or Mr. Simon?
I'm going to forward you.
I just want to be very clear about that all the parties to this are.
Of course.
Seeing the same information.
And as I said, this is the concept that we wrote in the motion, but I guess, I mean,
yeah.
hindsight's
So if
2020.
you have that language, Ms. Lim.
It seemed presumptuous, but I just forwarded the email and Derek will pull that up on his computer.
Okay. You should have screen sharing ability, Mr. Simon.
Excuse me, Chair. This is the court reporter.
Ms. McManus.
Thank you. I do not know who was speaking from the LUC. Was that Dan or was that?
Bert.
Thank you.
First Dan, followed by Bert.
Thank you.
Mr. Simon, are you able to put that up? Okay. Just so you know, we're seeing all your email.
Can you? Derek is telling me that somebody else is sharing their screen.
You are, Ms. Lim.
Well, then can you see this email that I have right here?
I can see the email that you have up.
Oh.
Okay.
This is the only thing that's seeing.
Okay.
So this is the email, and that is the language right there. Petitioner shall record in the Bureau of Conveyances.
Okay. Thank you. You can stop screen sharing.
Yeah.
Okay. Any other questions, commissioners, for any of the parties? If not, commissioners, the chair will entertain a motion that the LUC grant or deny HANOHANO LLC's motion to release and modify conditions filed August 10th, 2020, associated with its petition to amend the agricultural land use district boundary to the urban land use district for approximately 28.695 acres at Keahua, Kula, Maui, Hawaii, tax map keys 2-3-11-1 and 2-3-11-2. Is there a motion? Commissioner
Mr.
Ohigashi.
Chair, before I make a motion, I'd like to request a short recess of 3 minutes to attend to personal matters.
It's 1:17. We will reconvene at 1:20.
Thank you.
Don't leave, Nancy. Don't leave. Commissioners, I will entertain discussion or a motion on the matter before us.
Your Honor, Mr. Chair,
Commissioner Ohigashi.
I move that we grant in part and deny in part petitioner's request for petitioner's request. I think there is good cause and agreement to release conditions 1, 3, and 4 in all the parts and modify it. For F, 4H, 6A through 6D, 7 through 13, 16, 17, 21, 22, and 25. With regard to the petitioner's request to modify conditions 4A, 4B, and I believe C, D, E, G, and I believe there is, I move that we accept their conditions modifications. With regard to condition 5, I propose that we deny their request to release them from this condition. And that will go for conditions number 8, 14, 15, 18, 19, 20, and 23. And I believe that these are well, as indicated and agreed to, as indicated by the County of Maui, I think those are continuing obligations that should remain. With regard to condition number 6E, I believe that we should accept the position of the Department of Planning in regard to requiring that our executive director be empowered to ministerially release petitions from this particular condition. And with regard to condition 25, and that would, I'm sorry, with regard specifically to condition 23, I'm of the opinion that we should, I believe that the motion should read that we should not require any more annual reports by the petitioner, and that the county would be responsible for the enforcement of the existing conditions. As to condition 26, I think we should adopt the petitioner's language, and the petitioner shall record it in the Bureau of Conveyance of the State of Hawaii, an amended and restated certificate conditions, recognizing the commission's release of conditions and modifications of conditions as ordered pursuant to our decision and order, and restating the conditions affirmed by the commission, if any, pursuant to this decision and order. The amended and restated certificate conditions shall fully supersede and release the certificate of conditions that was recorded as document number 2005-105309.
Commissioner Ohigashi, may I ask you a clarifying question? Because I think the oral way that you stated your motion referred to both the retention and the deletion of condition 8. At the beginning of your statement, you said that you wanted to release conditions 7 through 13, but then you later said that you wanted to retain condition 8 in its original form, if I heard you correctly.
I apologize. I believe that condition 8 should be retained.
Commissioners, we have a complex motion before us. Is there a second?
Chair, this is Commissioner Wong.
Commissioner Wong.
You know, I want to second it for discussion purposes, but I also wanted to get more information about condition 4. So can I do that?
Certainly.
Okay, so I do second it, but I would like more information on condition 4 and all the letters in condition 4, just to make sure I got everything correct.
Okay. Commissioner Ohigashi, do you want to speak to that?
Yeah, my understanding is that the modifications essentially deal with the change in the composition of the CSC, and that would be number 4C. And
I'm sorry, I didn't, you got stuck there somewhere on my screen. Can you repeat that, please?
my understanding, to answer Mr. Wong's question, was that 4C, which is essentially the position that the condition that you're requesting, requires the change in the formation of the 3-person and 3-person composition of the CSC. And based upon the arguments or the statements made by the curator, as well as statements made by Don, Commissioner Chang, I came to the realization that, yeah, the composition of that should be composition of the CSC should be modified. As to the remaining conditions, it would fall in line with the amendments that they have made, that petitioner has requested. And that's essentially my understanding, as well as the
Commissioner Wong, followed by Commissioner Okuda.
Thank you, Chair. Sorry, I'm very slow after lunch. So if you don't mind, Commissioner Ohigashi, can we go letter by letter in condition number 4, like condition 4A? Is it to modify, retain as original, or release? Can you explain each letter individually, please?
Let me go pull out what I'm.
Thank you, Chair, for your indulgence on this.
Yeah, no, it's a complicated set of conditions, and this could be one instance in which our physically not being together is making this more burdensome.
Yeah.
First of all, I think we're not complaining about condition 4A, since everybody agrees that condition 4A was satisfied. Petitioner established permanent 60-foot and 100-foot zones around the basin wall.
I'm not hearing you clearly, Mr. Commissioner. This is Jean McManus. I'm not hearing you clearly.
Okay, maybe I should be speaking directly into it.
Thank you.
Trying to save paper, I haven't printed out everything. Condition 4A deals with the establishment of permanent 60-foot and 100-foot buffers. I think that there's nothing in anybody's filings that indicate that we don't agree that this has been completed. Condition 4B has been satisfied according to they incorporated the provisions of the CCNRs into the necessary conditions were imported to the CCNRs. Nobody disagrees with that. 4C was the attempt to modify the condition so that they can change the composition of the cultural CSC. And based upon what the curator indicated, I think that change should be made and should be allowed.
Chair?
Yes. Sorry, Ms. Lim. We're in deliberation. What would you like to?
I just to facilitate, I know you're in deliberations. We do have a table in our motion that Derek Simon can pull up to share screen for everybody to look at the same time. It shows the existing language, how we would propose to modify that language. If that's at all of assistance, it starts on page 19 of our motion and runs several pages. And not that I am suggesting that the commission is going to do everything exactly as we have it here, but at least you would have the exact language in front of you. It runs from page 19 to 25 of our motion. So if you would like
Thank you for that offer, Ms. Lim. We'll hold off for now. Commissioner Okuda.
Thank you, Mr. Chair. That was actually my question to Commissioner Ohigashi, if I may ask Commissioner Ohigashi. Commissioner, is your intent of the motion to adopt the petitioner's language, which appears on pages 19 through page, page 25 of the petitioner's filing, the language that's in the middle part or middle column of the table, which is under the column that says petitioner's proposal. Is that your intention by your motion, or do you intend something else?
That's my intention.
Okay, thank you. Thank you very much, Commissioner Ohigashi. Thank you, Mr. Chair. That was the only question I had.
Okay, so
Well, getting back at that, what that is on page 19, adopt. The purpose of the motion is to adopt petitioner's changes.
Mr. Ohigashi, sorry, I am also having a hard time hearing you speak when you're facing your computer or facing the other screen. Can you restate your last statement?
Yes, that is. I can go into each one of these, but my position is, that is what I answered Mr. Okudo.
To adopt the petitioner's recommendations.
That's correct.
The petitioner's motion in its entirety?
Yes. No, for condition number 4.
For condition number 4. Okay. We are in discussion, commissioners.
Chair, this is Commissioner Wong.
Commissioner Wong.
So I just wanted to reaffirm condition 4C. For Commissioner Ohigashi, are you following Commissioner Chang's recommendation or the petitioner's recommendation, the Movance?
My understanding is that I'm not Commissioner Chang's recommendation. There was not a recommendation that she accepted. She seemed to have accepted the position of the curator as and following 4C.
Okay. For the clarity of our deliberation, I think I've captured what the motion was. I'm going to share my screen, Mr. Ohigashi, Commissioner, and ask that you confirm or modify what I have caught so that everybody can see it. Are you seeing a sheet that lists the conditions to be released, modified, and retained? Are you able to see that?
Yes. However, the conditions 4C, 4D, 4E, 4I should be modified in accordance with the petitioners. For A and B, it should be released since they've already been. I'm sorry. For A and B should be modified. It should be modified in accordance with what the petitioners.
Okay, so I've just followed your instructions.
Sure. Chair, this is Commissioner Wong.
Commissioner Wong.
Where's condition 16?
It is not listed. It should be listed as a condition to be released. Commissioner Higashi, just confirming. This is the
Yes.
motion?
Yes.
Okay. Commissioner Okuda.
Thank you, Chair. Actually, your question to Commissioner Ohigashi answered my question. Thank you.
Okay. Commissioners, I can leave this up if it's useful or stop screen sharing.
Yes, Chair, can you leave it up, please?
Okay.
So condition 2 and 24, should it be retained as is? Should it be in there as retained as is?
Petitioner is not asking.
And petitioner is not asking for any changes?
It's not part of the motion.
Yes.
So you're asking for a clarification that 2 and 24 are remaining unchanged.
Yes, correct.
So what I would do is add them to this list. On the third line, commission conditions to be retained.
Thank you, Mr. Chair.
Okay. Sorry, my punctuation is slightly off. I was doing this on the fly to try and track it just for my own purposes. Commissioners, we're in discussion. We have a motion before us. Does anybody else want to speak towards the motion?
Nobody seconded. I think.
No, Commissioner Wong seconded it for the purposes of discussion. Commissioners, we are in discussion on the motion. If there's no comments, I will indicate a willingness to vote in favor of the motion, but I'll note for the record that it's interesting that we're taking up a form of the order for Hawaiian Memorial Park tomorrow, which in part deals with the protection of a heiau on a property. And I feel that the manner in which that we're dealing with that motion, that DBA, and a long-term protection and stewardship of the property, particularly as it retains to having funding for stewardship, as well as for established access, as well as for conservation easement to be held by a accredited land trust, in my mind, is a more superior way of dealing with these kinds of conditions than the LUC chose to in the past.
Chair, this is Commissioner Wong. Clarification, please.
Yes.
For condition 6E, is it Department of Planning or DOT? I think because I heard Commissioner Ohigashi said deep planning, and I thought it was DOT.
I think it was proposed by the Office of Planning, releasing a condition after acceptance by DOT.
Okay, thank you, Chair.
I think the difference is what I believe I heard the Office of Planning state, and Ms. Apuna can clarify. I think she might have suggested that the release be done by the chair, and Mr. Ohigashi's motion was that it be done ministerially by the executive officer. But perhaps I misheard Ms. Apuna. Ms. Apuna?
No, that's correct. We had that that the chair would release the condition upon the evidence showing such.
Thank you, Ms. Apuna. Commissioner Giovanni.
Thank you, Chair. For clarification, can I ask Commissioner Ohigashi to identify which of these conditions apply to the ohana housing that could be built or not built, and what would be clarify what would be the consequence if we vote in favor of this motion regarding ohana housing?
My understanding is that condition number 2 deals with ohana housing. And we're retaining that condition to prevent them from developing ohana housing. If it's necessary that they want to change their CCNRs or they want to pursue ohana development, then they would have to come back to the commission to modify condition number 2, make that case to us.
Thank you, Commissioner Ohigashi. I will be voting in favor of the motion.
Thank you, Commissioner Giovanni. Commissioners?
Mr. Chair. Mr. Chair,
Ohigashi.
If I don't want to usurp your authority, so I would be glad to accept the friendly amendment to, instead of the executive officer, that the chair would release ministerially.
I would just ask if, I mean, I can always use one fewer thing to sign in my life, but I would ask the Deputy Attorney General, Mr. Lau, whether I'm not familiar with us previously delegating authority to the executive officer in such a fashion. Do you have any thoughts to share with us? It's typically done to delegate it to the chair. Mr. Lau, you're muted. I cannot hear you.
Chair, this is Commissioner Wong.
Yes.
Because Commissioner Ohigashi has a motion on the floor for a friendly amendment, do we have to have a second? Do I have to second his friendly amendment?
I was ready to have it seconded just to see if it, but I want to see whether it was necessary and allowable.
Okay, because if not,
I'll inform it.
Okay, because if not, I'll agree to the friendly amendment.
Okay.
So we don't need to ask the AG.
Okay, and we can't seem to hear the AG at this moment. Can we hear you now, Colin? You're adjusting your mic? No. Commissioner Chang.
Thank you, Mr. Chair. I know we're all kind of exhausted. I guess I just wanted a clarification on condition 23, the annual reports. Now, what I heard the county say is that they actually found those annual reports to be helpful. That's how they knew that the status of the petitioner's compliance. And the LUC is still retaining some of these conditions. So I am wondering, how do we monitor their compliance of the conditions without the annual report? And I guess, so I'm trying to understand, what does this mean? Condition 23 be deleted with enforcement by the county? If someone can explain that to me.
I'll first ask Mr. Ohigashi to respond and then allow others.
Thank you.
I believe that that we don't have real enforcement powers anyway. That's the first. So the county would have to enforce it. Condition 23, they had no position, but they said that if there was less conditions, condition 23 could be. It doesn't seem to be onerous. What I believe is that the county, through its own enforcement agencies, through its own inspectors, through its own, through its own lawyers and corporation councils, they should be determining or trying to enforce whatever conditions that they are in there. And it's not necessary that we send out, require additional reports in this matter. If, however, the commission wants to amend it and continue to keep additional reports, I'm not going to object to it.
Thank you, Commissioner Ohigashi. Commissioner Okuda.
Thank you, Mr. Chair. I plan to vote in favor of this motion, including the deletion of the annual reports. And if I can just say very quickly why. I think the cost and the burden on the association for preparing the annual report outweighs any benefit. I do recognize the response by the county to my question about the annual report. But I think in the end, and I'm glad these conditions are kept regarding the heiau and cultural sites, because I do agree with the chair that we have a duty to present and future generations to protect the cultural heritage of Hawaii. But in the end, I believe the most effective way of protection of what makes Hawaii special is basically vigilance of the community And the vigilance comes from the fact that we shouldn't just assume that because somebody is submitting a report, somebody else is going to take care of it. I believe that sometimes the lack of a report will keep us from being lulled into a belief that somebody else will do a job, which really falls to all the citizens of the community. So for those reasons, I plan to vote in favor of the motion as stated.
Thank you, Commissioner Okuda. Commissioner Chang, do you have further comment?
Yeah, thank you, Mr. Chair. I guess I'm just trying to look at condition 4. There was a provision about submission of reports, and I'm trying to find which condition was that. Because if that's if that's being retained, deleted, or modified.
Commissioners, while Commissioner Chang is pursuing that, or did I would make a very brief space available to the parties if they had a specific response to Commissioner Chang's inquiry.
If I may, Chair, just for the purpose of providing
Briefly,
clarification.
Ms. Lim. Yes.
Thank you. 4E, Commissioner Chang, is the condition that requires the curator to provide reports.
Okay.
Now I've lost my place. There's a condition that requires a curator to provide reports to the commission, and what we had asked within 4E, for the reasons that I spoke about this morning, about that being burdensome for a curator, is to the curator will continue to keep the cultural curator selection committee updated, but we would ask that any reports from either the curator selection committee or from the curator, him or herself, okay, will be provided to the commission upon request, just so that doesn't become an administrative, and work burden for somebody who's there really to be a curator of the site.
Sorry, Ms. Lim,
Yeah.
Are you proposing a further modification or clarifying something you've said already?
I'm pointing to what we've already written in our motion. So the latter, clarifying what we already have said.
Thank you.
And Chair, this is Commissioner Chang.
Thank you.
With that clarification, because that is consistent with the representation and it's being modified, I accept that explanation.
Okay.
Thank you very much. I have no other comments or questions. I will be supporting the motion as well.
Going back to the friendly amendment offered by Commissioner Ohigashi and seconded by Commissioner Wong, since we were unable to receive any noting, I've put proposed language that would replace the fourth line. Does that capture Commissioner Ohigashi for 6E?
Yes.
Commissioner Wong?
Yes, sir.
Okay, we have an amended motion before us, commissioners. Is there further discussion?
Chair.
Commissioner Wong.
So, I'm still going back to Commissioner Chang's point regarding the reports. Because there is LUC conditions on there, I mean, how will the LUC know if the conditions are done or not? For example, let's say 6E, when will we know, how will we know if that DOT has given their okay?
Commissioner Wong, Commissioner Ohigashi accepted a willingness to modify that condition. I would concur personally. I'm not going to stop action over this, but I would prefer to see the reports retained.
Yeah, so that's what I'm talking about, Chair, is just because we do still have LUC conditions, and if we don't, how will the LUC know these conditions has been satisfied or not?
Are you asking Commissioner Ohigashi to amend his motion?
Yeah, just because Commissioner Chang brought it up. And I totally agree with her.
The nature of it would be to add 23 to the list of conditions to be retained. Though obviously the conditions reported on would be smaller because many had been released or modified.
Yes, thank you, Chair. If Commissioner Higashi wouldn't mind that friendly amendment.
As I indicated, I will accept it as an amendment. However, it's the duty of the petitioners to submit information with regard to 6E. So I don't think that is required. The second issue is that so long as there are conditions, I believe that the Land Use Commission can, and through the Executive Director's office, they can request for a status at any time with regard to the conditions that are still in effect. However, again, I will agree to a friendly amendment to have.
Okay, so Commissioner Wong, may I count your request for the friendly amendment as an agreement with the amendment as the seconder of the motion?
Yes, Chair.
Okay, so we have an amended motion before us followed. I now have Commissioner Cabral followed by Commissioner Axon.
Thank you, everyone. I like the idea of not having to force them to give annual reports. The fact that, as just stated, the Land Use Commission staff can contact the developer and the parties at any time to ask for a status update. And I'm very much in favor of, we all need to realize part of why housing is so expensive is that a poor developer never can stop paying a lawyer to write these reports at the rate this goes. So the sooner we can clean up these situations and release these poor developers and the people who have put themselves out there to create lots and to help provide for housing for our community, maybe the sooner more people will be willing to get strung out for 50 years trying to have somebody build a house. So I'm really in favor of trying to reduce the let them comply with our requirements and let them free. And so I think that I mean, I'm going to support the ultimate outcome in order to go for the better part to release and modify so many conditions. But I'd like to see more of our goal to clean up things and get them to where people willing to try and develop land and let people have houses and perhaps maybe contribute to having less homeless people. We would be able to have a great community without constantly, nothing against you lawyers, but I'm sure you're busy enough. I just don't want to have every developer support a lawyer into eternity just because they had to come through the LUC once in their lifetime. Thank you.
Commissioner Axon followed by Commissioner Giovanni, and I will try and respectfully, I think we're getting down to the short strokes on this one. I don't want to cut conversation too short, but we have a long agenda ahead of us as well. Commissioner Axon followed by Commissioner Giovanni.
Thank you, Mr. Chair. I just want to mention that I agree with the Commissioner Ogashi that Commissioner Wong's latest amendment is not necessary. I'm pretty sure the petitioner is going to notify LUC right away as soon as they comply with the condition. Having said that, I'll be voting in favor of the motion. And I just want to thank the petitioner for coming forward and putting forth these modifications. And I hope that, by cleaning up these docket conditions will make it easier for the county to enforce all these conditions. And it will serve as a guidance for them. Thanks. Thank you.
Thank you, Commissioner Axon. Commissioner Giovanni.
Thank you, Chair. I just want to say I agree with Commissioner Cabral, and I'm against the friendly amendment that would add back the reporting requirement.
Okay. As it stands, the motion is to retain the reporting requirement. The motion having been modified by the movant and agreed to by the seconder. Is there further discussion? The motion is displayed on my share screen. Further discussion, commissioners? Commissioner Ohigashi.
One last thing. I want to thank everybody for putting up with my ineptitude and trying to figure out what the conditions should and should not be. And I thank Jonathan for keeping good notes. And I ask that we proceed with this matter. Support my motion. Thank you.
Anything further, commissioners? Commissioner Axon?
I just want to thank Commissioner Ohigashi for all his research and efforts taking care of his county.
I better put on mute before I say something.
Okay. I might have to mute everybody, which is a power I have. If there is nothing further, Mr. Orodenker, would you please poll the commission on the motion before us?
Thank you, Mr. Chair. The motion is to grant in part and deny in part as enumerated, the motion as enumerated by Commissioner Ohigashi. The conditions to be released are conditions 1, 3, 4F.
Sorry. I was trying to save the document before it got lost.
6A to 6D, 7, 9 through 13, 16, 17, 21, 22, and 25. Conditions to be modified are 4A, 4B, 4C, 4D, 4E, 4G, 4I, and 26 as proposed by petitioner. Conditions to be retained are conditions 2, 5, 6E, 8, 14, 15, 18, 19, 20, 23, and 24. The chair will be authorized to release condition 6E once appropriate evidence is submitted to the LUC that the dedication of the right-of-way and setback has been completed to DOT's satisfaction. The chair is authorized to sign the order. Commissioner Ohigashi.
Aye.
Commissioner Wong.
Aye.
Commissioner Axon.
Aye.
Commissioner Chang.
Aye.
Commissioner Cabral.
Yes.
Commissioner Okuda.
Yes.
Commissioner Giovanni.
Aye.
Chair Scheuer.
Chair votes aye.
Thank you, Mr. Chair. The vote passes unanimously. The motion passes unanimously.
Thank you. Thank you, Ms. Lim, Mr. Hopper, Ms. Apuna, Mr. Simon. It is 2 o'clock on the nose. We're going to I'm going to propose a 15-minute recess, and then we will proceed from 2:15 till 4 o'clock without break to take up our next agenda item, HALEKUA Development Corporation, Oahu.
Thank you very much, Chair and Commissioners.
15-minute recess, reconvening at 2:15.
Got to save that screen.
Chair?
I'm about to email it.
Okay.
Oh, okay.
Thank you, Jonathan. Once you finish, I'm going to change the screen to the.
Oh, I can stop sharing now. Sorry. This is an action meeting on docket number A92, 683, HALEKUA Development Corporation, Oahu, to consider the successor petitioner as to parcel 52, Ho'ohana Solar 1 LLC's motion for modification and time extension, and Haseko Royal Kunia LLC et al.'s motion in opposition to successor petitioner as to parcel 52, Ho'ohana Solar 1 LLC's motion for modification and time extension, In docket number A92-683, the petition to amend the agricultural land use district boundary into the urban land use district boundary for approximately 503.886 acres of land at Waikele and Ho'ai'ai, Ewa, Oahu, City and County of Honolulu, Hawaii, tax map keys number 19-402, lot 1, as well as a portion of lots 52, 70, and 71. The chair would like to note for the record that the motion in opposition filed by HASECO is better characterized as a memorandum of opposition for the purposes of this proceeding. Will the parties for docket number A92-683 please identify yourselves for the record? You may need to enable your audio, beginning with the petitioner.
Good afternoon, Chair, members of the commission. Everybody can hear me, I hope.
Yes.
Thank you. This is Jennifer Lim representing Move On HANOHANO Solar One LLC. With me today is my associate, Mr. Derek Simon. We also have another counsel. His name is John Pete Minot. He's my partner here at Carl Smith. He needs to be please let into the room. He's in standby sort of waiting room scenario.
Raise your hand and we will let you in using the raise your hand function.
No, the raise your hand function.
We're joining, okay, we're joining.
And Ms. Lim, don't botch our proceedings by saying these are simple, the way you did
Those-
with the first one.
The freeze is stricken. Oh.
Going on. For HASECO.
Good afternoon, Chair. I'm Stephen Chung with the Imanaka Asato Law Firm, and with us, we represent HASECO Royal Kania, and I am co-counsel with Michael Lau from the Morihara Lau and Fong firm. We just have one witness today, Ms. Shireen Tam, who is an officer of HASECO Development, which is the manager of HASECO Royal Kania.
Thank you. City and County. DPP. You're muted if you're trying to note your appearance. City and County of Honolulu.
Chair, this is Scott Derrickson.
Yes.
Yeah, the Eugene Takahashi is supposed to be joining after 1 p.m. So he should be on and he should be in the room.
I'm here.
Blanche Chong. Okay, yeah, there you go.
Okay. Sorry, there is 2 unmute buttons in our setup. I only pressed one of them. I apologize. This is Eugene Takahashi, Second Deputy Director, Department of Planning and Permitting. Also joining me is Molly Stebbins from our Office of Corporation Counsel.
Thank you. Office of Planning.
Good afternoon, Chair, members of the Commission, Deputy Attorney General Don Acuna, on behalf of the State Office of Planning.
Okay. Is there anybody else here for this docket? No. Please let me update the record now. From August 17th, 2020 until recently, the Commission received the following documents. A92-683 HALEKUA Development Corporation successor petitioner as to parcel 52 Ho'ohana Solar One LLC's motion for modification and time extension and their exhibits 1 through 15. Requests for extension of time to respond from the Office of Planning and the Department of Planning and Permitting, to which the Commission responded on August 26th. Petitioner HASECO Royal Kania LLC's motion in opposition to successor petitioner Ho'ohana Solar One LLC's motion. And the joinders of HRT Realty LLC and Jupiter Investors 2 LLC. The Office of Planning's response to successor petitioner's motion for modifications and time extension. The City and County of Honolulu DPP's position statement. Correspondence from the HASECO representative regarding the amended certificate of service, and from the successor petitioner as to parcel 52, the reply to the petitioner HASECO Royal Kania LLC's motion, or more accurately memorandum in opposition, a first list of exhibits, including, and then exhibits 15 through 53, a first list of witnesses, a reply to the Office of Planning's response to their motion, a reply to DPP's letter regarding the docket, Imanaka Asato and Stephen Chung's notice of appearance of co-counsel for petitioner Haseko Royal Kuniya LLC, Haseko Royal Kuniya LLC's declaration of Shireen S. Tam and exhibits 1 through 4, and their declaration of Michael Lau and exhibit 5. On September 29th, the commission mailed the October 7th through 8th, 2020 agenda notice to the statewide Oahu, Maui email and mailing lists. From October 1st through 6th, the commission received public testimony from numerous members of the public, business, and nonprofit organizations, as well as government officials that have been made part of the record and are posted for the LUC website. Now let me run over our procedures for the remainder of today that we will follow through till tomorrow. First, I will give an opportunity for the petitioner to comment on the commission's policy governing reimbursement of hearing expenses. I will then recognize written public testimony that has been submitted in the matter. I will then call on individuals who are attending and are pre-registered to testify. You will be brought into the main part of the meeting, sworn in, given 2 minutes to testify, after which you will be questioned by the parties and the commissioners if they have questions for you. We will go through all the individuals pre-registered for testifying, and after those individuals, we will turn to anybody else who wishes to testify in this matter. After all testimony has been heard, I will close public testimony on these proceedings, and petitioner HANOHANO Solar will make their presentation. Following HANOHANO Solar's presentation, we will receive comments from the commissioners. Then we will give Haseko Royal Kuniya an opportunity to make their presentation and call their witness. After that, they will be questioned by the commissioners. Then petitioner HANOHANO will be given the chance to provide any rebuttal, and the commission will ask its final questions of the parties before beginning deliberation. As I noted, after our break, due to our technical difficulties today and our need to end proceedings at 4 o'clock, my intention is to proceed as far as we can to 4 o'clock without taking a break for the remainder of today, and then taking this matter up tomorrow morning. Are there any questions from the parties on our procedures for today, starting with the petitioner?
No questions from petitioner, Chair.
Haseko?
No questions from Haseko.
County?
No questions from the City and County of Honolulu.
OP?
Chair, Office of Planning submitted a revised Exhibit 1 this morning and I think it's Exhibit 2, which was provided to the commission and I believe to the commissioners and the other parties.
Thank you, Ms. Apuna, I did not have that written down because of its late arrival. Thank you for updating that portion of the record. It's so updated. Anything regarding our procedures, Ms. Apuna?
Thank you. No, Chair.
Okay. Ms. Lim, have you reviewed HAR 1515-45.1 with regard to the reimbursement of hearing expenses? And can you state your client's position on the matter?
We have reviewed it, and HANOHANO Solar 1 will comply with those requirements. Thank you.
Okay. I'm now going to bring up the list of written testimony on this matter. This will take me one moment. We have written testimony, and if you hear your name being called and you're in the waiting room to testify, then I'm going to ask you to use the raise your hand function and ask to be let in. Kimo Spector or Rebecca Dehuff Matsushima for Hawaiian Electric. Use the raise your hand function if you wish to testify on this matter orally, in addition to your written testimony. Otherwise, this will be acknowledgement of your written testimony. Tyler Dos Santos Tam and Melvin Silva for the International Union of Bricklayers and Allied Crafts Workers, Local Number 1. Jill Baptiste of the Hawaii Carpenters Union. Nathaniel Kinney of the Hawaii Construction Alliance. Mr. Kinney. Ryan Kobayashi, the Government Affairs for Hawaii Laborers Union Local 368. Joy Kimura of Hawaii Laborers and Employee Cooperation Education Trust Fund. Dean Okimoto. State Senator Michelle Kidani. Denise Yamaguchi of the Hawaii Agricultural Foundation. Chris Delaunay of the Pacific Resource Partnership. The Chamber, oh, Chris Delaunay. I will admit you into be a panelist. Please enable your video and audio. I will swear you in. I'll ask you to state your name and address for the record and then give you 2 minutes to testify. Please enable your audio and video. Mr. Delaunay, please enable your audio and video. Mr. Delaunay is not yet able to enable his audio and video. We'll come back to him and go on. Dan Kochi of the Chamber of Commerce of Hawaii. Samantha Ruiz of the Ulu Pono Initiative on behalf of Murray Clay. State Representative Ty Cullen. State Representative Nicole Lowen. Keith Hayashi of Waipahu High School, principal of Waipahu High School. State Senator Glenn Wakai. Mr. Delaunay, are you able to unmute or enable your video? If not, I'm going to ask LUC staff to put you back into the audience and see whether we can re-promote you. Finally, written testimony from Albi Mateo and Wayne Nakamoto of Royal Kunia Community Association. I see some people whose names I've called are in the audience. If you're not using your raise hand function, I'm assuming that you're not wishing to orally testify on this matter. Can we try to readmit Mr. Delaunay from Pacific Resource Partnership?
Chair,
yes.
I don't see Mr. Delaunay in the audience anymore. He may have tried to sign off and then trying to sign back in.
Trying to sign back in, yes. Okay. In the meantime, is there anybody who is an attendee who wishes to testify in this matter? If so, please use the raise hand function and I will admit you in order. I'm going to start with Mr. David Tenoye. When I bring you in, please enable your audio and video. I will swear you in. Are you able to, okay, I see your mute is off. Are you able to enable your video?
I'll do that right now. There you go.
There we go. Nice to see you.
Thank you.
Do you swear or affirm the testimony you're about to give is the truth?
Yes.
Okay, please state your name and address for the record, and then you have 2 minutes, followed by questions.
My name is David Tenoy. I'm with Arm Towel Corporation. Business address is 2024 North King Street, Suite 200, Honolulu, Hawaii, 96819. Thank you for the opportunity of testifying this afternoon. And like you said, you know, it's trying times, and especially in this format, very difficult. And I appreciate the opportunity and your guys' commitment to public service. I wanted to just let the commissioners know and the parties know that I'm available in case there's any questions. I also represent RP2. The last time we were in front of this commission regarding Royal Pinilla was about 2.5 years ago. RP2 was a predecessor in interest to the Haseko lot. You know, it took almost 3 years of negotiating with the parties that the sale finally was negotiated and came through. And Haseko took, the closing just occurred less than 2 months ago. So everybody's pretty fresh as far as the Haseko side, but I've been involved in the negotiations and in constant contact with the various parties. You know, as Arm Tower, we were in a very good and interesting situation because like HRT, you know, Haseko is our client. The Department of Ag on the Ag Park is our clients. We also are the clients for the potential buyer for the industrial area from HRT. So we're right in the middle. We're able to assist all our clients and trying to move the Royal Kunia project forward after over 25 years of being vacant. I know there's been a lot of prior owners and a lot of broken promises, but I think we can, you know, that the parties can continue to work together and actually need to work together to keep the projects moving forward. And I just wanted to let the commission know that I'm available for any questions because I've been around for like the past 2.5, 3 years working with the parties to try and keep the projects moving forward. If you have any questions, please feel to call on me. Thank you.
Thank you, Mr. Tanoy. Questions, starting with the petitioner. Ms. Lim.
Mr. Tanoy.
Yes.
Hi, thank you for being here today. It's nice to see you. I haven't seen you in months and months, even on video. It's good to see you. I'm going to ask you something, but I know the answer, but I do want to hear it from your mouth. There's an amended and restated, a fourth amendment to amendment and restatement of Memorandum of Understanding that was dated March 16th, 2020. Can you tell me who the parties are to that agreement?
That will be the Department of Ag and RP2 LLC.
Thank you. So that became an agreement when RP2 was owning parcel 71, the parcel that's owned by Haseko now?
That's correct.
Is that agreement then assigned to Haseko upon Haseko's acquisition of parcel 71?
I believe so. At least I understand that Haseko has assumed the obligations.
Thank you very much, Mr. Shinoe. I don't have any further questions.
Okay. Haseko.
Haseko has no questions.
City.
City has no questions.
OP.
No questions.
Commissioners. Commissioner Okuda.
Thank you very much, Mr. Chair. Thank you, Mr. Tanoy. Can I ask you to tell me whether you agree, disagree, or you don't know about certain statements that were made by the petitioner in their reply memorandum? And I'm asking this because usually there's no reply to the reply. So since you're the person who seems to know and been in the middle of this, if you can tell me, let me quote you this sentence and tell me whether this is an accurate statement, it's not accurate, or you don't know. And I quote, "At least since 2007, the off-site infrastructure improvements for the Ag Park have been the sole contractual obligation of the owner of parcel 71, which today is Haseko." Is that statement true, not true, or you can't tell us one way or the other?
You know, since as RP2, that we didn't take possession till September 2017, you know, I can't state the truth or otherwise on that statement because it goes back to 2007. Yeah.
Okay. Let me read you another sentence from the petitioner's reply, and that actually follows, you know, that sentence which I just read. And for the record, this is from the top of page 5 of the petitioner's reply. Okay. In May 2018, its predecessor in interest to parcel 71, RP2 Ventures LLC, parent, quote, RP2, close quote, close parent, represented to the commission in no uncertain terms that it dash and it alone dash would be responsible for completing all of the infrastructure improvements for the ag park. Is that statement accurate, not accurate, or you can't really say one way or the other?
I'll say it's mostly accurate. I mean, as one of the landowners in this petition area, we're obligated under the conditions in the DNO, and that included providing needed infrastructure for the Department of Ag's agriculture park.
Okay, and let me just read this last sentence and same question about this sentence. RP2 subsequently memorialized those representations through an infrastructure agreement with the DOA, which HASECO freely admits it assumed when it purchased parcel 71. Is that statement accurate, not accurate, or you can't tell us one way or the other?
You know, that statement is accurate in the sense that, yeah, it does reflect the general terms of the agreement. RP2 did enter into an agreement, the Fourth Amendment to the MOU with the Department of Ag, the dates, and that was as a result of a prior meeting in front of the LUC. I think at that time, Chairperson Wong directed the parties, RP2 as the new owner, the new owner at that time, and the DOA to kind of take more time and work it out. And then, so we continue to work with the Department of Ag. We came up with some dates. You know, to be honest, the Department of Ag was pushing. We understood that there's been a lot of broken promises along the way and that they were anxious to get their project moving forward. We know because, as I mentioned earlier, we're the engineers for that project. So we helped them with the agriculture cluster. We did the agriculture subdivision. We knew where it was going. They needed to ensure that they had the necessary infrastructure and irrigation lines. So we were pushing that as forward as RP2, and that was moving forward. We did agree to, if you notice as an attorney, that there is like a general clause in there about allowing amendments to the date, you know, for good cause or something along that line. I wanted to make sure, because I did represent to DOA that you know, we'll be moving forward with it, but we can't guarantee. Some of the dates are pretty fast, but we understood that they wanted to show progress when they go back to the legislature for funding. And as you like the deadlines of June 30th, 2021 coincides with the fiscal year, you know, things like that. And then, you know, I represented to them that it's likely it'll be a little bit further than that, but we'll be under construction by then. So the document says what it says, Commissioner Okuda, but there is, there was some built-in leeway from our side, because we understood we were trying to accommodate their financing schedule, but knowing how the project was going to lay out, that it would be unlikely that we could hit the deadlines directly. Currently, we are up to date. We have the plans are being reviewed by DPP, which I think the deadline was May 31st to have those plans submitted. So we're moving forward. But we, you know, from the engineering side, we knew that it would be very difficult to hit the completion deadlines in time.
Thank you very much, Mr. Tanoy. Thank you, Mr. Chair. No further questions.
Okay, Commissioner Chang.
Thank you. Good afternoon, Mr. Tanoy. Nice to see you.
Thank you.
When you made those statements regarding RP2, you were representing RP2, is that correct?
RP2, and like I'm here now, RP2 is it's sort of like a subsidiary from RM Powell.
Okay.
Yeah, RM Powell. So that's why I kind of wear two hats at the same time. And RM Powell is, like I mentioned earlier, we're the engineers for all the major parties that are involved here, this area. So we're, like I mentioned, even the last time before the commission, we're like the common denominator and the facilitator to kind of get the people together. Because I could, you know, as the former director for DPP, that project has been struggling 25 years. And even when I was at the city and the last kind of developer came forward, the department was kind of helping them along, trying to embrace it, trying to get it going again. And that failed. That was back in 2007, 2008. So, you know, having the right players in place, I think was the way that the project could move forward, and having that opportunity to kind of help and facilitate that moving forward really helped. And after 3 years, we got the right players all lined up. And I think we can just continue to move forward given the time and, you know, a little bit more effort.
Great. Thank you. And I guess that's the question I have is who are the right players? As I understand it, the petition area includes all of parcels, not only 71, but 79, 78, 70, parcel 1, and parcel 52. My question is, with respect to who is responsible for the off-site infrastructure development? Is that a shared responsibility with all of the landowners in the petition area? Is that your understanding as someone who is facilitating all of the right players at the table?
You know, my perspective looking at it, Commissioner Chang, is that, you know, the entire petition area under the petition in the Land Use Commission, everybody's responsible for the conditions in the DNO, unless it's specified otherwise. But there were individual agreements among the parties themselves over the years. And those are some of the reasons why it made it challenging and why it had to be, you know, between, I think when looking back at it, when the original developer started to be getting into financial trouble and selling off pieces, he maintained some of the responsibilities, took their responsibilities on on parcel 71, the parcel that he retained while selling off the pieces and things like that. So after going through several owners and, you know, developers and all that, it was the project was all bifurcated and cut and broken up. And if you look at the parties who were, when we stepped in, you had Canyon Financial. They were money people from the mainland. They weren't going to build. They weren't looking at building anything, more like flipping it. You had HRT, who was, you know, the Weinberg Foundation, who was trying to support the project in the early days. But, you know, like I said, the private agreements between the landowners, HRT, the responsibility for the infrastructure, things like affordable housing, was all put on parcel 71 as part of the deal for the transfer among each other. And so, you know, they're just sitting there. They can't do anything because they don't have infrastructure, and that wasn't the responsibility. So we needed to put the right parties. We needed to put a builder developer in place. We needed to help HRT, because they're not a developer, move on and, you know, find value in the property and kind of move on and put the right developers in place. And that's why we're fortunate enough to have another client, Haseko, who's a builder developer, who can take on the heavy financial burden of the because that parcel 71 is carrying a lot of the offsite improvement load, a lot of the infrastructure load on it, because that was Herbert Horita's last piece he's holding on, and he took the responsibility on. And so, and they required the multifamily lot that they purchased from HRT too. And we put in an industrial developer for the industrial side that's under contract with HRT. So ultimately, the right players will be in place who will look forward to developing the lot and not there for money, but in the long term. So when I think that as far as the LUC and the DNO, all the parcels in the petition area are responsible.
And I guess that's the question I have is more related, is more related to parcel 52. The Robinsons are the underlying landowner. Is that correct?
Yes.
So have they been part of these discussions with respect to obligations under the, for the offsite infrastructure?
You know, I've been having regular conversations with the Robinson folks, and, you know, I kind of joke to myself that they're the last original, the OG for the whole, you know, Royal Kunia phase 2. They're the only original party, you know, that's left over, and they've been along the ride, and a lot of broken promises to people along the way. So, and, you know, I really support them with their PV project moving forward. Want them to succeed because they've been waiting a long time. They have a different, and that's when it comes with the attorneys, Commissioner Chang. You know, one side saying they're not obligated, another side saying they are obligated, and that's why my concerns with the, you know, the current matter before this court is like the attorneys. I'm an attorney.
Mm-hmm.
At a certain point, things start to take on their own lives and start going in. I'm trying to, you know, be part of it, and I think a lot of people involved are trying to not get it to spiral in that direction. It can be resolved. I think you just need, you know, the attorney's got to state their positions, and there might not be an agreement, but ultimately it'll end up at the same place where the parties will have to sit down and figure it out.
And Mr. Turner, I guess that's the ultimate question I have is because you're right. You're not an attorney. I mean, you're not an attorney in this, you are an attorney, but not in the context of this proceeding.
Yes.
And you are trying to facilitate so that this moves forward. But ultimately, because I know Robinsons are not represented in this proceeding. We have the lessee who's proposing to do the solar project, but we don't have the underlying landowner, the Robinsons. So, and there appears to have been other agreements that may have been structured as far as who's obligated. So I just wanted to confirm with you, who's been helping to facilitate these discussions. One, have the Robinsons been part of those discussions as the underlying landowner for parcel 52? Because eventually that land will go back to them. And two, is it their understanding that they have an obligation as a landowner from the original petition for these offsite infrastructure developments?
I think for your first question, you know, I've been in regular discussions with Robinson. We haven't been talking specifically about the matter before you. You know, I've been talking with the Robinson. I never knew there was a 2015 decision with a prior solar farm project of the requirements for the DOA infrastructure. So when RP2 took possession of the property or became the owner, we started to work with Robinson because we knew for the irrigation line and the utility lines, we will need easements and consents from the Robinson folks. So I've been in contact and, you know, and there's been a lot of, you know, verbal agreements over the years that the Robinson attorney wanted to kind of memorialize because people come and go. So, you know, it's about time everybody should kind of, you know, put these agreements in writing. So there's an understanding and expectation. So there've been a lot of conversations with myself and Stephen Mao from the Robinson attorney side with these other things, but never did we really go into the discussion about the solar farm and their obligations or, you know, perceived obligations or whatever moving forward. But it's, you know, it's always been the conversation we're relating to how RP2 could meet the conditions in the MOU that we had with DOA and continue with the design for the irrigation lines and the utility service and negotiate for the easements. You know, when I found out that the prior solar farm project had that responsibility, I was thinking, and looking at this being similar, I was thinking, well, if I knew that, I would have asked them for help getting the easements from the Robinson because we were both on the hook. But because you know, I was still working on trying to get the easements approved from the Robinsons for the irrigation and the utility service to the ag part.
Okay, well, thank you, Mr. Tonoi. So I guess what I'm understanding is that you have been having conversations with the Robinsons, but not on this particular matter, nor on the matter of whether it is their understanding that they have an obligation to contribute to the offsite infrastructure as a landowner in the petition area.
Yeah, I think, you know, again, I think Stephen Mao had mentioned that he doesn't think that they have a responsibility.
Okay, okay.
That they're somewhere during the history of the 25-year history, you know, there are some matters before the commission or among the parties, and so that they're not responsible. But
Okay.
yeah, that's probably their position. Like I mentioned, from outside looking in, I look at it, everybody in the petition area is responsible to start with, and then there's some agreements among themselves. Yeah.
All right, thank you so much. I have no other questions.
Anything further, commissioners? Anything further, commissioners, for this witness? Thank you, Mr. Tonoi. I'm going to move you back into being an attendee. Our representative from PRP is now with us in audio and video. Can I ask you as a favor if you would instruct me as to the proper pronunciation of your last name?
Delaney.
Delaney.
Yes.
Sorry about that. Do you swear affirm the testimony you're about to give is the truth?
I do.
Thank you. Please proceed.
Okay. Good afternoon, commissioners. Chris Delaney with Pacific Resource Partnership. We are in support of this project, and you know, As Hawaii faces an economic crisis without parallel in its history as a state, Ho'ohana provides a valuable opportunity to stimulate our economy, both by creating new jobs and creating infrastructure which can help lower energy costs for consumers and businesses. There's been recent forecasts by UHERO anticipate significant shortfalls in employment numbers versus what it forecast about a year ago. The declines will be steepest in 2020 and 2021. UHERO predicts that Hawaii employment will not return to 2019 levels before 2026. Ho'ohana will employ approximately 175 construction workers in 2021, a period when some of the worst shortfalls in employment are anticipated to occur. Additionally, Ho'ohana will provide substantially more clean renewable energy than a solar project proposed in 2015 for this site. So when completed, this newly proposed solar project will be capable of generating enough energy annually to power approximately 19,100 homes, which will advance the state closer towards achieving its goal to generate 100% clean energy by 2045. Thank you for this opportunity to testify.
Thank you, and thank you for your persistence and patience in being able to give your testimony. Questions for the witness, starting with the petitioner.
No questions from petitioner, but thank you very much for your testimony.
Haseko.
Haseko has no questions. Thank you.
County.
City has no questions.
OP.
No questions.
Commissioners. Commissioners, any questions? If none, I have a question. You testified as to the economic impact, beneficial economic impact from the solar project. Which would provide a greater impact if this land was actually being used to develop housing as originally envisioned in the docket, or a solar farm?
Sorry, your question is what would be better?
Which would provide a greater economic beneficial impact?
Yeah, well, we think that this solar farm will provide a good economic impact, which creates more jobs. And also it's important to create more solar at this time to reach our goals of getting clean energy by 2045. So I think it's good use of the land. That's our position.
Which would provide a greater economic beneficial
I don't have that
impact.
information.
Housing or housing as was originally intended with this docket, or a solar farm?
Yeah, I don't have that information in front of me right now, the cost benefit analysis. Thank you. Thank you for your question.
Thank you. Anything further, commissioners? Thank you very much for your testimony.
Thank you.
I will move you to be an attendee. And Mr. Jeff Overton, again, if you are in the attendee for this meeting and you wish to testify, raise your hand and you will be promoted to be a panelist. I'm letting in Mr. Overton now. Good afternoon, Mr. Overton.
Good afternoon.
Do you
Jeff
swear
Overton, no.
do you swear or affirm the testimony you're about to give is the truth?
I do.
Okay.
Now, I believe I'm part of the petitioner's presentation, and so should I be deferring to that moment?
Can you speak louder, please?
Okay, is that better?
Yes, that is better. Thank you.
Better? Okay, I'll hold the microphone up here. Should I be deferring to that moment in the agenda? I'm on the East Coast, it's 9 o'clock, so I'm just trying to move into my role here. Sorry.
Ms. Lim?
Chair, Mr. Overton is one of our witnesses, so he's not a public testifier. He would be the first witness we call.
Okay.
Thank you. Sorry.
Okay. Okay. Is there anybody else who's an attendee? I'm going to move you back to being an attendee for now, Mr. Overton. Is there anybody else who's an attendee who wishes to give public testimony on this matter? If so, raise your hand. If not, I will stop public testimony for now and I will ask for any disclosures from the commissioners. Commissioner Axon.
Thank you, Mr. Chair. After hearing all the testifiers and reading all the names, including the past testifiers, I want to disclose that I can say all of those individuals or organizations, I have some kind of interaction with them one way or another from my previous life. And in particular, both opponents and supporters of this motion. And in particular, I want to mention the Hawaii Carpenters Union. I just want to tell the commission that I don't work for the Carpenters Union, although I work for Hawaii Carpenters Apprenticeship and Training Fund, which is a different entity from the union. I don't get any financial interest or benefits from the union. So having said that, I can assure the commission that I can be impartial regarding this docket during the deliberation.
Okay. Before I go to that, I note Ms. Apuna has raised her hand. Ms. Apuna?
I apologize, Chair. I actually had a question about the proceedings. I know I was supposed to ask earlier, but I can wait till after
Okay.
Commissioner Axon's.
After disclosures. Okay. Commissioner Axon has made a disclosure. I'm going to ask each of the parties if there's any objection to his continued participation in these proceedings, beginning with the petitioner.
I'm so sorry. Petitioner has no questions or concerns with Commissioner
No
Axon's
objections to
disclosure.
Commissioner Axon's continued participation.
No, sir.
Haseko.
Mr. Chair, Haseko has no objection to Mr. Axon.
City and County.
City has no objections.
Okay.
No
OP?
objections. No
Okay.
objections.
Are there other disclosures, commissioners? If not, until I saw Mr. Overton was going to be a witness, my wife works for G70 with Mr. Overton. I gather they are consultants on the petitioner's project. She is not working on the project and has no financial interest in the outcome of the project. But I want to make that disclosure and offer any of the parties the opportunity to object to my continued participation in this matter, starting with the petitioner.
And petitioner has no objection. Thank you.
Haseko.
Haseko has no objection, Mr. Chair.
City.
City
and
has
County.
no objections.
Ms. Apuna.
No objections.
Okay. Any other disclosures, commissioners? If not, Ms. Apuna, you had a procedural question?
Yes, Chair. Actually, two. Well, the first one isn't a question, but OP actually has two witnesses for their case. Mr. Funakoshi and Mrs. Fujimoto. And then besides that, I know that you mentioned as far as the proceedings that there would be petitioner's case and then Haseko's case and then rebuttal. Will OP and the county be able to put on their position or case?
Case as well. Sorry, Mr. Lau or Mr. Ordenker?
Mr. Chair, yes, it's intended that OP and the county put on their case.
Yes, that's what I thought.
Thank you.
Did that address all your questions, Ms. Apuna?
Yes, thank you, Chair.
Okay, it is 3 o'clock. We're done with public testimony. I said we weren't going to take a break before 4 o'clock, but there might be a need for a 5-minute bio break before we go in through the final proceedings, commissioners. Is that desirable? Okay, it's 3 o'clock. We will reconvene promptly, exactly at 3:05. Gashi and Giovanni. Okay, 3:05. We're back on the record. let me quickly see if there's, and Ms. Apuna started on this by noting her witnesses. Ms. Lim, are there any other documents that you want to add in addition to what you've already filed with the commission?
Well, in addition to the documents that we've already filed as exhibits, there are certain orders that have come out of the commission within this docket that I would assume are in fact part of the record by virtue of being within the docket. So if that is the case, then there's not additional documentation that we would be filing at this time, although I do need to reserve the right to perhaps submit additional exhibits in response to things that may come up throughout the proceedings.
Understood. Yes. Mr. Lau, same question, or Haseko's attorney, whoever's going to represent on this.
This is Steve Cho, Mr. Chair for Haseko. Like Ho'ohana, we would like to reserve the right to the extent that an issue comes up to submit additional information.
Okay. Same questions for the county and LP.
No, we don't have anything else to add.
Okay.
Thing.
Okay. Great. Ms. Lim, why don't you proceed? And keep in mind, we do have a hard stop of 4 o'clock today.
Understood, Chair. Thank you. Thank you, commissioners and parties. It's been a long day already, but this is a very important project for our client, Ho'ohana Solar One LLC, and I believe it's a very important project for the state of Hawaii because the solar project that Ho'ohana is proposing is going to make it one of the largest contributors to renewable energy in the state of Hawaii. In some respects, although I know these are dangerous words to use, in some respects this should be simple because
I previously instructed you, Counselor.
I'm well aware of that, but let me just explain. In January of 2015, this commission, after several hearings, deliberately, but then unanimously voted to approve the use of parcel 52, which is owned by Robinson Cuneo Land, parcel 52 for the development of a solar farm. And that solar farm was going to be developed by Ho'ohana, okay? The commission took deliberate action, but did so in a timely manner. And the property was urban and everything looked good to go. And then unfortunately, although the commission issued its order in January of 2015, which I'll call the 2015 order throughout these proceedings, when HECO then went to the Public Utilities Commission to request approval for the power purchase agreement, of course, that was a power purchase agreement between Ho'ohana and HECO, the PUC rejected that. The PUC at that time, it was in 2015, rejected a handful of power purchase agreements. So that could have been the end of this project. The project that the commission had authorized, we still wanted to go forward, but we didn't have a power purchase agreement. HECO then issued another round of requests for proposals seeking additional renewable energy projects. Around the same time, the state of Hawaii also passed a new law requiring that there be 100% renewable energy by 2045. These things came together where Ho'ohana then submitted a proposal in response to HECO's request, and the project was selected. A significant, there's actually several significant beneficial aspects about the new project. One is the power purchase agreement's already been approved. So we're really coming before you as the last really discretionary permit or discretionary request that we have. The city permits have been issued. Building permits have not been issued, but the city permits have been issued. The PUC has approved the power purchase agreement. But we do want to get commission approval because the project that Ho'ohana wants to develop now is different from the project that the commission approved in January 2015. The biggest difference is that the 2015 project was a 20 megawatt project, which was a sizable project at the time. However, right now, the project that has been approved by the PUC is for a 52 megawatt project. That's the project that we're requesting approval for today. The 2020 solar farm is a 52 megawatt system paired with a 52 megawatt, 208 megawatt hour battery energy storage system with 4-hour duration at full capacity. It includes related electrical improvements and structures and utility tie-ins. The request that we made in our motion that we filed in August was pursuant to the Commission's good cause standard, that we get permission again to make the changes to the project from a 20 megawatt to a 52 megawatt. And there's some differences in, some of the appurtenances with the project. And then the operational time frame. It had the project that got approved in 2015 gone forward, it would have been in place, we're asking for this current project to be in place, developed, operated, and then fully decommissioned within 43 years of the Commission's approval. So that's a little bit longer than the project that had been approved in 2015. Obviously, we have a lag period of, over 5 years between the approvals. As I mentioned, we have taken into consideration the Commission's good cause standard, and we've articulated that in our motion. Some of the differences that we think contribute to the good cause would be not only the substantial increase in renewable energy, this being a 52 megawatt project, but also this very efficient use of the land. Parcel 52, again, that Ho'ohana leases from Robinson Kunia land, is approximately 161 acres. The project that we're proposing right now, the 2020 solar farm project, uses about 157 acres of that property. So it is entirely within the urban district. That was an engineering challenge, and Mr. Larry Green can speak to that. He's the project manager. But when you compare that against the 2015 project, which was only going to provide 20 megawatts, nothing to sneeze at, but 20 megawatts on 124 acres, and now we're doing 52 megawatts on 157 acres, we're looking at a 27% increase in the amount of land that we're being used, but we're getting a 160% increase in renewable energy. And in addition to the project supporting Act 97, which was the law that requires 100% renewable energy by 2045, I also want to spend a minute talking about Act 23 that was just signed into law in September of this year, just last month. Act 23 eliminates the use of coal in Hawaii for electrical production. And I'm going to read some of this. The state is committed to a decisive and irreversible transition away from fossil fuels and a swift transition to a clean energy economy powered by 100% renewable energy. This renewable energy transformation will help stabilize and strengthen Hawaii's economy by reducing its dependency on imported fossil fuels, fostering innovation and clean energy job growth, helping protect Hawaii's environment by greatly reducing carbon emissions, and positioning Hawaii as a global leader on climate solutions. Coal is the largest source of carbon dioxide emissions in the world. Coal-fired power plants are responsible for 70% of the nation's mercury emissions. And when mercury emissions are released into the air, and again, I'm taking this all from Act 27, when mercury emissions are released into the air, they accumulate in soil and in water where it contaminates food consumed, especially fish. Mercury is especially threatening to pregnant women and young children. Mercury is one of the leading causes of preventable birth defects, including brain damage and cerebral palsy. Federal regulations to reduce mercury from coal power plants have been significantly weakened by the current federal administration. The Hawaii legislature finds that coal power, as one of the dirtiest fossil fuels, has no role in Hawaii's clean energy future. The purpose of the act was to eliminate, or is to eliminate, the use of coal in Hawaii for electrical production. This solar farm, Ho'ohana Solar Farm, is a major contributor to Hawaiian Electric's ability to stop reliance on the AES coal-fired plant and instead rely on clean renewable energy. So we believe that if nothing else the Commission hears today, Act 23 and the prohibition on coal And the 52 megawatts of clean energy that this project wants to provide provides the commission good cause to approve the rather modest amendments that we're requesting. I have lots of details about the project that I'm not going to read at this time, as I think that they'll come out better in a more interesting way through our testifiers. But I do want to touch on a couple of the other highlights. Again, keeping in mind the commission's good cause standard. Why should you approve this request? Again, the project was approved in January 2015, but we need a little more time, and we want to do a 52 megawatt project instead of a 20 megawatt project. This 2020 solar farm is going to provide educational benefits to the community. HANOHANO is going to partner with the Maui Economic Development Board, which is a nonprofit entity that's developed a statewide and internationally recognized diverse renewable energy curriculum for grades K through 12. Earlier, there was a recognition of testimony that was received by Principal Hayashi from Waipahu High School, Principal Keith Hayashi, who expressed support due to HANOHANO's commitment to provide development training to teachers on renewable energy through a STEM-based curriculum. That is one example of maybe an indirect financial and clearly a good community benefit that this project would bring. We also have to acknowledge the support that we've gotten from other folks, and not to belabor the public testimony role that you read through earlier, Chair, but we're very appreciative that Royal Pinea Community Association, who's our neighbor, has unanimously supported this 52 megawatt project, and in fact have been in support from the start, and appreciate that HANOHANO has been transparent, has always tried to keep them informed. We've also gotten lots of support from both business leaders, the farming community, and elected officials, everyone able to touch on something or find something in this project that they believe is supportive of important needs in the state of Hawaii. It's probably better that I don't read out all those names because I wouldn't want to leave anybody out, but certainly the union support, the business support, and the elected officials who submitted testimony, we're extremely grateful for that. And we think that that too provides the commission some comfort that our request is consistent with its good cause standard. I believe through Chair's question earlier about whether HANOHANO wished to file any additional exhibits, I should have rephrased my response and asked if through that we were officially admitting our exhibits into the record, but we would want to certainly admit all of the exhibits that we've filed thus far into the record. And I want to also say that, and that's exhibits 1 through 14 that were filed with our motion, and then exhibits 15 to 53 that we filed on September 25th. And again, I do ask that those get admitted into the record officially.
I believe they're part of the record, but I'll ask for any clarification if we need to formally ask for them to be admitted into the record and ask for any objections from the parties, from either Mr. Lau or Mr. Ordenker.
Haseko does not have any objections.
Dan?
Are you asking, Mr. Chair, are you asking?
Procedurally, do we need to go through the admission of things, or are they already considered to be part of the record having been submitted by the parties?
No, we don't.
Okay.
They've already been submitted by the parties.
That was my understanding.
Yeah.
So we don't have to go through that formalized process, Ms. Lim.
Thank you very much, Chair. For our process for today, and we do recognize that the commission's time is short today, we have listed 7 potential witnesses on our list of witnesses. Some of those witnesses we absolutely intend to call on, and perhaps that'll be today or tomorrow morning. Other witnesses we have on reserve or rebuttal, depending on the nature of the commission's questions and areas that the commission may have a greater interest in. Certain witnesses like the Sohrab Rashid, who prepared the traffic assessment, We filed written direct testimony by Mr. Rashid. There did not appear to be concerns from the parties. So we intended to rest on his written direct testimony, but we could certainly call him if needed. Similarly for Dr. Monahan, who prepared the cultural report for the project. We've submitted written direct testimony for him. We didn't intend to call on him, but certainly we know the commissioners often have very distinct interest in that topic area, so we could bring him forward. And the same with a few of the other witnesses that we've listed. The key witnesses, or let's say our primary witnesses, would be Mr. Jeff Overton on land use planning and permitting, Mr. Lawrence Green, who's the project manager, and Mr. John Wallenstrom, who's a development consultant working on the project. And I'll just say one thing further before we get into the actual presentation through witnesses. You can't see the room that we've been in all day over here, but due to the social distancing that we, the HANOHANO legal team, is trying to comply with, there's some separation between myself and my colleagues, Mr. Minot and Mr. Simon. And it's somewhat hampering our ability to communicate. Everybody is dealing with this. And so in light of the fact that we have several parties who, to our great disappointment, had filed papers against us, and in light of the fact of this somewhat cumbersome hearing process, we're hoping, Chair, that in order to facilitate an orderly and efficient hearing, that the chair does authorize all counsel for HANOHANO to participate in the proceedings consistent with Hawaii Administrative Rules 1515-67. We will use that permission judiciously, but there's just, because we're not next to each other, we can't confer as easily as we would otherwise.
The intention of your request, Ms. Lim, is so that other counsel can jump in as necessary.
Correct, Chair.
Yeah, I would suspect the same thing, that with Mr. Lau and Mr. Chung, that they would want to, as co-counsel, be able to
That is correct, Your Honor. Yeah, Mr. Chair.
Okay. I haven't been promoted to Your Honor yet. And since I'm not an attorney, it's unlikely. Okay, I don't see a problem with that.
Thank you very much, Chair.
So Ms. Lim, how do you want to use the rest of our 37 minutes together?
Well, if I may, particularly because Mr. Overton is 6 hours ahead and it sounds like he's got a terrible cold as well. If we could bring Mr. Overton in as our first witness and have him go through his presentation, and hopefully he can be released and get a good night's sleep and be left alone tomorrow.
Okay. Mr. Overton, I'm not sure why you left God's country of Manoa to the East Coast, but
35th wedding anniversary.
There we go.
Stole my bride away from Cape Cod, so we're here. It's 50 and the winds are 50. It's lovely. I've got a sweater under my aloha shirt.
Do you swear or affirm the testimony you're about to give us the truth?
I do.
Okay, please proceed, Ms. Lim.
Hi, Jeff. Thank you very much for sticking with us. I'm going to just jump right into it, Jeff. You filed written direct testimony you provided written direct testimony that we filed as Petitioner's Exhibit 45. Is that correct?
Correct.
Okay. I'm going to ask you to summarize that, but first let's go through some preliminaries, if you would. What is your position at Group 70, please, or G70?
Principal planner.
And how long have you been in that role?
About 37 years, 32, well, not as principal planner, but 32 years with G70, 37 years in the profession, EIS work, master planning, permitting.
And your resume was filed as Petitioner's Exhibit 39, is that correct?
Yes.
Have you testified before this commission before in areas of land use planning, permitting, and Chapter 343 analysis?
Yes, I have. Several times going back to 1990.
With that, if I may pause and ask the commission's indulgence to confirm that Mr. Overton qualifies as an expert witness in the fields that we've identified.
Specifically land use planning, 343 analysis, and what was it?
Land use planning, land use permitting, and 343 analysis, yes.
Any objections from the parties?
Steve Chung for Haseko, no objection.
County.
City has no objections.
OP.
No objection. No objections.
Commissioners. He's so admitted.
Thank you very much. Okay, Jeff, why don't you summarize a little bit from your written direct testimony about what you know about the project, your history with the project, and then what I plan on doing is pulling up certain exhibits regarding the project siting, the 138 kV line, and a few things like that. We'll talk about those in detail, but why don't you give the commission sort of an overview from your land use permitting and planning perspective about this project, please.
That'd be great. Thanks. So G70 was retained by HANOHANO in February of 2014 as the land use planner originally for the proposed solar farm that was granted the approval by the commission in 2015. And that motion is petition exhibit 16, the 2015 order, we're calling that. And HANOHANO also retained G70 for land use planning, permitting in connection with the current solar farm project. As Jennifer had mentioned, it is a 52 megawatt photovoltaic system paired with 52 megawatt, 208 megawatt hour battery energy storage with a 4-hour duration. So the batteries are all in the newer projects now. It's mandatory under HECO. Again, 161 acres roughly owned by Robinson Cunha. This is the parcel 52. It's the same parcel that was subject to the prior order in 2015. I've been principal planner on the project in both cases and working with our team to go through modification to the county's conditional use permit process and now supporting the action before the commission. We have a petition exhibit 1, and I believe Derek Simon's going to launch a few screen share exhibits that show, and I'll just try to roll through it. A graphic that shows parcel 52, which is the boundary, and the site plan in here. This will also be in your packet that each of the commissioners would have. Thank you, Derek. Okay. I'm trying to juggle because I just have a laptop here, so I can't see everything you're saying. If you go to the, well, anyway. So the shaded area is parcel 52, and that is the increment 3 of the Royal Cunha Phase 2 project. And you can see the other parcels that are called out here, all associated with Royal Cunha Phase 2.
Jeff, if I may, I'm going to pause there.
Good.
Do you know which parcel is owned by Haseko?
Okay, so I've got to go through the list here, but parcel 71 is really the key central development parcel. The HRT parcel is parcel 1. And I've got a table in here that has the list of all the owners in here. I just have to pull that up effectively. Yeah. Parcel 71 is really the key parcel.
The key Haseko on parcel.
Yes, yes. So parcel 1, parcel 70, I'm sorry, 942 is 123 acres owned by HRT. 94002, parcel 70, parcel 78, parcel 71 are all Haseko parcels. There's a small parcel, which is a school, elementary school parcel owned by RKES. And then parcel 3 is parcel 052, which is increment 3, is the 161 acre Robinson Cunha land parcel.
Perfect. When you say increment 3, you know, not all of the commissioners who are here today were on the commission back in 2014 and 2015. So what are you talking about increment 3? Maybe if you could give the commission a very brief summary about what is this entire petition area and how is it planned to be developed?
Yeah, well, David gave a very good kind of high-level capture of it, but Herbert Harita had to divide up portions of the project, and the portion that Robinson's had were basically obtained from Herbert to kind of trade out as he was struggling. Robinson came on board and picked up what is the third increment up against the gulch of 3 phases of Royal Kunia Phase 2. So you have a portion that's up against Kunia Road, kind of the central larger parcel, and then what was intended to be the final phase actually was supposed to be a golf course at one time. Robinson's picked it up, and that's the parcel that HANOHANO has established their lease deal for the solar farm.
So this entire petition area, this was considered Royal Kunia Phase 2, and then
Yes.
this Phase 2 was going to be developed in 3 increments.
And to help folks orient to the Ag Park piece is the portion that has the label Kunia Road, and you can see the roughly rectangular piece that Derek is waving out here. Does that answer your question, Jen?
Yeah.
Okay, sorry.
That's cool. I'll tell you what, you please continue. I'll try not to interrupt you.
No, it's good. It'll help it flow. So I'm very familiar with the motion that HANOHANO has filed, requesting modification to recognize the change in the project from 20 megawatts up to 52 megawatts. So basically densifying the position of these panels in the system, and it's technically feasible, and you'll have subsequent witnesses that can speak to that. And they're able to achieve the 52 megawatts under the new ECO PPA. And so it does not, it adjusts the starting date and stopping date that were originally set up under the 2015 decision and order, but it will not take any longer for this project to get built once they say go. Jennifer had mentioned earlier the total project duration of 43 years, and then this would revert. There's required to decommission. So one question that you might have is that, approving the 2020 solar project will allow parcel 52 to be used for this interim use that's very beneficial, not just to the environment as a renewable energy project, but to the state in achieving the 100% renewable goal. If the 2020 solar project here, HANOHANO, does not go forward, parcel 52 will likely remain undeveloped and unproductive. It's always been sort of the parcel on the edge of this development plan and was always pushed way out there. So the new group that's come in, and hopefully they are successful and proceed, this would be a final increment 43 years from now for this development plan.
So Chip, just on that point, I want to make sure the commissioners follow what you're saying. I mean, parcel 52, where we want to as an interim use, but it's a long-term interim use. I mean, it's within our lifetimes. It is urban property and it is planned for development, but it was the first, second, or third increment of the development planned within this entire petition area.
That's correct.
Was it the first, the second, or the third?
Oh, the third, the final phase.
And would there be infrastructure reasons for that?
Well, it's challenging, of course, to support all the homes with sewer, water, drainage, roadways, et cetera. And there's also some transportation concerns that have plagued the project's ability to move forward. And so that has really been a damper on any additional interest in converting this land to a subdivision in the near term.
So the increments that would go ahead and construct the infrastructure would be increment 1 or increment 2 before it actually hooked up into increment 3?
Correct.
Let's change gears if we could a little bit and talk about view impacts. I know G70 prepared various view analyses. Maybe you can talk to the commission about those, and we'll start out with Petitioner's Exhibit 11. That was filed with our motion. That was before there were any opposition pleadings. And if you just summarize for the commission what's there, and Derek is pulling that up too.
Yeah, the base question, would the development of a solar project at this location generate adverse visual effects that could affect the surrounding neighborhoods? Now, previously, the commission had already made a determination in 2015.
Excuse me. This is a court reporter. I'm having very difficulty hearing you. Can you please speak louder? And can you repeat what you've already said?
Yes. So I'm sorry, I'm just speaking maybe too quickly, and I'll hold the mic right next to my mouth. The project that was approved by the Land Use Commission in 2015 was examined very closely for the concern, potential concern of views, public vantage points that may view the solar farm and have some potential adverse visual effect. At the time we went through the 2015 approval, it was found that there was no significant visual effect to the adjoining community or significant public vantage points. We've gone back and prepared an updated view study, that is Petition Exhibit 11, that included view planes from 8 regional vantage points surrounding Parcel 52. And we created accurate depictions of the future conditions of the solar array and the facility and computer visual simulations. And the findings of this match up again, that the 2020 solar project will not adversely impact any views or sight lines because it is low profile, hugging the existing topography. These are low-rise solar panels. They extend approximately 6 feet off the ground and will have a perimeter fence with 7-foot-high landscaping screen that surrounds it. So as these photos show and the depictions, the 2020 solar project is really in the background and will not create an eyesore for the surrounding communities.
In fact, looking at the item that's on the screen right now, is the solar farm even visible from this vantage point?
From most distant locations, because of topography and intervening vegetation, it's not.
Thank you, Jeff. Are there any other photographs in that exhibit? Okay. Now, more recently, Jeff, I know G70 did some other visual analysis. For example, Petitioner's Exhibit 31.
Yeah,
are you familiar with that item? And Derek is pulling it up.
Good, thank you. More recently, G70 prepared renderings of the 2020 solar project to assess the views from the HALEKUA-owned property at TMK 9400271. That's the larger piece of the adjoining property. And these renderings also account for the landscape concept plan that is prepared for the 2020 solar project. We're obligated to have a landscape buffer on the perimeter of the project as it matches with the community. And is evident by this rendering, even from the closest boundary of Parcel 71, the solar array will not be readily visible. Proposed fencing and landscaping should mitigate virtually any potential view or contact impact from the 2020 solar project.
Thank you, Jeff, for discussing views. And I do see when I look at this exhibit that the panels really aren't visible. I'd like to turn, if we could, and help you or have you please explain to the commission how the 2020 solar farm is going to connect to the HECO grid. Derek will pull up the appropriate exhibit, and I'm basing all this on your written direct testimony. But.
Thank you. Well, I'll preload Derek's graphic.
Exhibit 25 would probably be the first one to look at.
So all these solar projects, of course, have to connect up with the solar grid, and they do so through gen tie. They call it sort of the generation tie. It's the plug-in of the solar system after it goes to the substation and then eventually into the power grid. So the location, just answering Jennifer Lim's question here, the 2020 solar project will connect to the HECO grid through an existing 138 kilovolt transmission system that runs just outside of Parcel 52's northern boundary. This is when you drive through here and when you drive up the H2, or you drive across Cunha Road, up Cunha Road, you'll see the major power lines cross at this point. And our petition exhibit 25, we have a photo that's just taken within the past month. The vantage point from the closest boundary of the HASECO-owned Parcel 71, looking across Parcel 52. Now, these power lines and poles for the existing 138 kV system, HECO system, as well as a lower voltage 46 kV system are clearly visible in the distance. Those are existing poles, that we didn't simulate those. So G70 prepared several graphics to show the commission how the 2015 solar project would have connected to the HECO grid and how the 2020 solar project will connect up. Our petition exhibit 24 shows ... This will show how our 2020 solar project ties into the existing 138 kilovolt system. The
So just
tie-in.
for,
Yeah, go ahead.
I just because it's such an important point. So the 2020 solar farm, is it building or establishing a new 138 kV line?
No, we're tying into the existing 138 kV system.
So how is that existing 138 kV line, how is that shown on this exhibit 24, please?
The tie-in, and thank you, Derek, for zooming a little bit. At the top of this long red arrow that says 1,600 feet, and it depicts this short segment of green tying into the parallel 138 lines to the substation and battery component on the HANOHANO site. So again, the 138s all exist, the big overhead towers, and we're just doing this short connection in the MAUI direction, basically heading upland, away from the HANOHANO site, also further away from the HASECO site. In terms of distances, the location of the 2020 solar project substation is even further away from the other petition area properties than the substation was planned in the 2015 solar project. We've adjusted that. The current distance, this is in petition exhibit 27, is about 1,320 feet to the nearest petition area property of parcel 71. Before it was roughly 1,057 feet. So we're about a football field or a soccer field further away in the new design, which I think helps mitigate any potential for view. But it won't be seen. It's way out there and it's the grade is flat. So you just won't.
Please keep your voice up. I'm losing you.
Thank you.
Thank you, Jeff. If we could, because of your permitting experience, I'd like to just quickly look at petitioner's exhibit 28 and have you tell the commission whether or not the 2020 solar farm as approved by the city complies with the applicable zoning setback requirements.
The 2020 solar project absolutely must comply with the setback requirements around its perimeter. And again, we have gone to great lengths from an engineering standpoint to make it a very efficient layout and use panels that are high efficiency in a very dense layout. We still need to respect the setbacks that are mandated by the city. That's shown in here.
Is that the blue lines?
So we have the shaded panel arrangement. That is the old layout. The 2020 project takes it right to the edge of the buffer, the setback distance, but complies with the city's setback requirements across this.
Ms. Lim, I'm just doing
Yeah.
a time check. It's 3:46. We have a hard stop at 4.
Do you know, Chair, if I may, especially because Mr. Overton he desperately sounds like he needs to get some rest.
I think the whole commission does too, but I admit Mr. Overton more.
I would like to turn him over to the commission for questioning, but I do need to reserve the ability to call him back because we haven't touched on all of the areas that are within his area of expertise.
Yeah, no, nor do we necessarily if we were to get through this docket in 2 days. I'm not sure whether we will be able to fully plumb the depths of all of your expertise. So, I mean, it's your case to make, but I'm concerned about the level of detail that you're going into and our ability to thoroughly hear from all the parties, ask questions, and deliberate.
Your concerns are shared by all of us. I'm going to ask Jeff 2 more questions, and then I would turn him over for questions from the commission. And Jeff, those questions are, and again, it's all in your written direct testimony, but G70 retained a biologist to do an assessment on the property because, of course, this property hasn't been developed. None of the petition area has been developed, the whole area of it. Were there any issues of concern that came out of that biological assessment, Joe?
No, the project will not have an adverse effect on biological resources. Eric Ginther with ECOS did the survey, and there were no findings of endangered species, plant or animal, or any federally declared critical habitat located on or within parcel 52.
Thanks, Jeff. And then my last question for you is sort of a catch-all. When taking into account your expertise, land use planning, land use permitting, Chapter 343 issues, do you believe that parcel 52 is an appropriate location and that this is an appropriate time and use of that property, meaning the development of the 2020 solar farm?
Absolutely. As with the 2015 solar project, the 2020 solar project is a highly suitable interim use of parcel 52, which is consistent with all of those land use criteria that are set out in the Sustainable Community Plan, the Commission's rules, and the applicable decision and orders in the docket. Most importantly, the Commission determined that development of the solar farm at parcel 52 is consistent with the Hawaii Clean Energy Initiative, which aims to achieve 70% clean energy by 2030 and 40% of it from locally generated renewable sources. So we have to go with these projects that are really low-hanging fruit. And this one has already gone through an approval process. It's now over twice as large as it was back then in terms of renewable energy. By providing the 52 megawatts of clean renewable energy, it's a prime example of how we can go forward with a renewable energy source in support of the state policies.
Thanks very much, Jeff.
Okay, if Mr. Simon wants to stop screen sharing, Mr. Overton is available for cross, starting with Haseko, followed by the county, OP, and then commissioners.
Thank you, Mr. Chair. Mr. Overton, my name is Stephen Chung, and I am co-counsel for Haseko Royal Kunia. So prior to submitting an application to go forward with the solar farm, I would assume that the petitioner conducted some due diligence, and as part of that due diligence, the petitioner would have reviewed the amended findings of fact, conclusions of law, and decision of order that this commission issued in October of 1996. Would I be correct?
Yes.
Okay. And in reviewing the 1996 amended findings of fact, there are provisions in there, paragraphs 184, 185 to be specific, that discuss drainage requirements for the petition area. Do you recall reading those findings of fact?
I know that drainage was an important part of the overall master planning for infrastructure.
And do you know that condition number 16 of the 1996 amended decision and order provided that, I'm going to read this, and please correct me if I misread it. Condition number 16 says, petitioner shall provide drainage improvements for the subject project and shall coordinate off-site improvement with adjoining landowners and developers and or other federal, state, and city agencies. Do you recall reviewing such a provision or such a condition?
So in cases where we're dealing with a quasi-judicial findings and decision order and conditions, we're always deferring to council in terms of the formal interpretation of these conditions. As a land use planner, I don't think I can delve.
Mr. Overton, please make sure you speak right into the mic just for the benefit of the court reporter.
Would you like me to repeat the last answer?
Please.
So Mr. Chung was asking if I was aware of a specific condition number 16 from a 96 DNO.
Right.
And of course, we were not part of that original finding. You're talking more about the due diligence that was done in preparation for this. And since we are not counsel for the solar farm developers, we always defer to counsel in terms of interpretation of the specific legalities of those conditions. I'm not a civil engineer, can't speak to that. I am aware that you need to work with drainage on the property and we have to make provisions for the development.
So, but as part of your due diligence, didn't you review the amended decision and order and note that there were drainage provisions or drainage requirements?
We know that Park Engineering did a master plan for drainage on the property. And so it was never, of course, implemented because the development was suspended so many times in a row. And so they do the best they can. And with the rules changing on stormwater quality and
If I may, I actually think it's a kind of, for the witness, I think it's a kind of simple question. Did you read or are you aware of that condition?
I am aware of a drainage provision.
So,
Continue, Mr. Chung.
Thank you, Mr. Chair. Mr. Overton, are you aware of the existence of a 1996 drainage master plan that covers the entire petition area?
We have a civil engineer that would speak more specifically to the drainage requirements and the historical. I can't speak to the details of the drainage master plan. The work that we were doing was for a conditional use permit for a utility installation. And I'm sorry, I can't give more detail than that. I really defer to the civil engineers as well as the attorneys interpreting any of those conditions.
But my question to you is, were you aware that there was a 1996 drainage master plan?
All of the zone changes in the city and county require a drainage master plan. So that's part of what Herbert had to go through in the original rezoning.
Well, were you personally aware that there was a 1996 drainage master plan that impacted Lot 52 or parts of 52?
In our studies for the solar farm, again, we deferred to civil engineers or attorneys to tell us where things could be done in terms of solar on the property. So those requirements and meeting the requirements for the conditional use permit for the utility installation were actually satisfied with the city. integrating all those prior agreements.
Okay, I'm not asking you whether or not your position is whether it's enforceable or not. I'm just asking you whether you were aware that there was a 1996 drainage master plan that impacted parcel 52.
So probably the straightest answer, because I swore I would tell the truth, is I have some general understanding of a drainage master plan.
Okay, were you personally aware that the drainage master plan called for a retention basin to be developed on parcel 52, just north of the border of the golf course, the existing golf course?
In the old plan, there was an area in the plan that was called out. And again, as we understand these, and my experience with is that as these developments progress, they're often placeholders in the overall master planning scheme, and that it's not a hard, rigid, specific infrastructure land use allocation there.
But were you aware that the 1996 master plan called for a retention basin to be developed on the southern portion of parcel 52, just north of the golf course?
I saw one version of a master plan that had a drainage basin there.
Mr. Chung, I'm going to note the time, and we do have a hard stop at 3:50 or at 4 o'clock. It's 3:56. I don't know how much more you have right now and how you want to proceed.
Well, I do have just a few more areas. It probably will go beyond 4 o'clock, but probably
Unfortunately,
not
I
more
will lose quorum, so we can't proceed past 4 o'clock. My inclination at this point is to call for a recess till 9 a.m. tomorrow, and unfortunately, we will have to call you back from Cape Cod, Mr. Overton, for continued cross. I assume you're available?
You should speak with my wife first. No, go ahead. I'll be attending, sir.
Okay. I will ask the parties to keep in mind that, Commissioner Wong?
Yeah, I just want to point out to the parties that this matter is the third thing on the agenda tomorrow. So we will be taking up 2 other matters before we come back for this one.
Okay,
That's not a helpful finding.
Thank you for that clarification, Dan, but that is the way our agenda has been published. So we will
What time would you like me to testify on my anniversary tomorrow?
It's up to your, excuse me, Mr. Overton. I did not know it was your anniversary tomorrow, but we are doing the best that we can to try and manage this proceeding. Your counsel took an extraordinary amount of time to even get to this point. So we don't have an ability, as I think you well know, to manage our proceedings to the hour and the minute. If you are to be called, you're going to have to work with Ms. Lim on that.
Thank you.
If not, I don't know what we're going to do if you're not available for cross-examination.
Is there any way we could start at 9 o'clock Hawaii time?
The agenda is not set up in that manner.
If I may, there may be, because these questions are going to a very specific item that's really more within the area of expertise of a civil engineer. And we have identified a civil engineer who we could perhaps have instead of Mr. Overton to respond to some of those questions.
This is, unfortunately, among other things, we are out of time today. I'm a bit frustrated with the manner in which the case has been put forward. Mr. Lau, do we have the ability to reorder the agenda to allow for at least one witness to be called before proceeding with the adoption of the order in Hawaiian Memorial Park and the taking up of the Maui landfill matter?
You do.
Do I need a motion from the commission to reorder the agenda in such a manner?
I don't believe so. I believe you as the chair can order that.
Okay. I'm willing, at the inconvenience of the County of Maui and the parties to Hawaiian Memorial Park, to allow no more than a half hour for the full cross-examination and conclusion of Mr. Overton's testimony at 9 a.m. tomorrow, and then we will proceed. Understood, parties?
Yes.
Mr. Chair,
Understood.
Mr. Ohigashi.
I just wanted, I think I informed everyone that I will not be available till 10:30 p.m.
Okay. Thank you for that reminder. With that is 4 o'clock. We are going into recess to 9 a.m. tomorrow as instructed.
Thanks.